May it please the Court, Chief Justice and Justices, I appear for the applicant together with my learned friends, Mr. Bishop, Mr. Mbikiwa, and Mr. De Beer.
Chief Justice, members of the Court, together with my learned friend, Mr. Darfel, I appear on behalf of the first respondent, the Minister of Finance.
Thank you, Ms. Pillay.
May it please the Court, my learned friends, Mr. Marcus, Mr. O'Sullivan, and Ms. Matsala and I appear for SARS. If you would permit me one moment, Chief Justice, I would like to pay tribute to a member of our team, Advocate Nelsie Soboza, who recently passed away. She was a valued member of our team in this case, and we remember her.
Thank you for bringing that to our attention, Mr. Trengrove. Shall we observe a moment of silence? You may proceed, Mr. Trengrove. I'm sorry, Mr. Manager.
Thank you, Chief Justice. There are three routes we submit on which the Court can confirm the declaration of invalidity, and any one of those three routes would be sufficient on its own. Route 1 is what we refer to as the taxing power. We deal with that in Part 3 of our heads, that the Constitution reserves the power to tax to legislatures. That power includes the power to set and alter a rate, and Section 7.4 confers that power on the minister. And we submit that's a breach of a bright line rule, and that would render Section 7.4 unconstitutional. Route 2 is the New Africa route. We deal with that in our heads of argument at Part 4, that if the Court holds that a rate adjustment power may in principle be delegated and falls to be assessed contextually, Section 7.4 fails that assessment, and this is the route that the High Court followed to find in favor of the applicant. And we submit that the judgment of the High Court in that regard is unassailable. The third route is the plenary power point. We deal with that in our heads at Part 5, that Parliament may not delegate the power to amend the body of an act of Parliament, and that Section 7.4 does exactly that. And that too we submit is a bright line rule. But we also submit that the Court only need to reach Route 3 if it rejects Routes 1 and 2. If you find for us on either 1 and 2, we don't need to go to Route 3. And for that reason, we will make our submissions in the sequence in which I identified the routes. I'll deal with 1 and 2, and then 3 at the end. And then say something about foreign law and remedy. Before I address the three routes individually, we make brief submissions on the nature of VAT as a tax. VAT is a charge on consumption of goods and services. At 15%, an amount equal to 15% of the value of the supply is added to the price of every taxable good or service. The ultimate consumer of the goods or services pays the VAT as part of the price of the goods or services. VAT is collected by the supplier of goods or services, called the vendor, who accounts to SARS for the VAT collected and submits a return. The consumer pays VAT at the time of the transaction consent, i.e. at the time of supply of the goods or services, at whatever rate then applies. If the rate changes, nothing can be done for the consumer to recover any VAT paid, because the taxpayer, which is the consumer, pays at the time of the transaction, and the tax they pay at whatever rate at the time of the transaction. And the taxpayer files no return, there is no assessment, and there is therefore no mechanism by which a difference can be identified, still less returned to the consumer. And that is why an increase under Section 7.4 is factually irreversible. All parties agree that VAT, once paid, cannot be refunded to the consumers who paid it, even if the imposition of the VAT and its collection is later invalidated or reversed by the legislature. So if you take an example, a 1,000 basket of goods, VAT at 15% is 150 rand, at 15.5% would be 155 rand, and the consumer pays the additional 5 rand to the till, to the vendor. She pays it on every purchase, every day, for as long as the altered rate applies. There is no return, no assessment, and no refund mechanism by which it can ever be returned to the payer. It is different from income tax in that sense, which is because income tax is paid by the taxpayer on assessment and can be refunded. And one can appreciate then the impact on the consumer of an additional increase in the VAT. Then I turn to the first ground, which is the argument that one can't delegate a taxing power, and that is what Section 7.4 does. Our jurisprudence draws a distinction between taxes being imposed by the state and regulatory charges imposed by the state. And the distinction is recognized in the case law, and the bearer of the power to raise the charge follows from which side of the line the charge falls. And in this regard, I highlight three propositions of law which are accepted by the respondents or not seriously contested, which are relevant to this ground of attack. The first is that only legislatures may impose taxes. SARS accepts that only Parliament and the provincial and local legislatures may impose taxes. And the Minister accepts that Parliament may not divest itself of that taxing power. And you'll find that in the heads of argument for SARS at 1 and 9.1 and the paragraphs 9 and 1 and 9.1, and for the Minister 31.1 to 31.3. The second is that VAT is a tax, is not a regulatory charge. Its dominant purpose is to raise revenue. The Minister records that this is not disputed, and that's in the heads of the Minister at paragraph 49. SARS accepted it in the High Court, and no party suggests that an alteration of the VAT rate is directed at regulating conduct. There is therefore no characterization question at all in this case. VAT is a tax. And the third proposition is the proposition I've already made, which is that a VAT increase cannot be reversed. VAT, because it's collected transaction by transaction, it cannot be adjusted retroactively, and it cannot be refunded to a consumer who paid it. Both the respondents accept it in their heads of argument. On this court's unambiguous precedents, we submit this common cause propositions are sufficient for the court to declare Section 7.4 unconstitutional and invalid under the first route, because the power to raise taxes or to impose a tax burden lies with the legislature and cannot be delegated to the executive. And there's a good reason why our Constitution reserves the power to tax for legislatures. It's because it is one of government's most intrusive powers. It determines how much of a person's money the state takes and how much remains for that person to use as she chooses. That power cannot be determined by bureaucrats in Treasury or even by ministers in cabinet, irrespective of their expertise. It should be determined by elected representatives after a deliberative process, not before, and the deliberative process takes place afterwards with public participation. That process we submit is not an obstacle to good governance. It ensures good governance. The legislative process ensures that we all have our say and that all issues and perspectives are considered and debated in public. That process ensures that on issues that affect us all, better decisions are taken and that those decisions are legitimate. Decisions on how much tax we pay that are imposed with no public participation, no public debate, and excluding the views of all those whose parties are not in government are likely to lead to poorer decisions and to be illegitimate. And we highlight the facts of this case to demonstrate that point. We submit respectfully that the Minister and SARS ignore this core principle, or at least underplay it. And SARS says the DA asks the wrong question in this case. SARS says that the proper question is whether Parliament may impose a tax and determine the rate at which it must be paid, but delegate to the Minister of Finance a power to make short-term or temporary adjustments to the rate. We submit that the framing of the issue in this way is really aimed to avoid the consequence of the bright line rule that the power to tax may not be delegated to the executive. Because if it is wrong that the delegated power is the taxing power, we submit that bright line rule applies and it renders the section invalid. We say the premise of SARS framing is mistaken for three reasons. First, referring to the minister's adjustment as temporary or short-term makes it appear as if the power is modest, but it is far from modest. What lapses, you will see from the section, what lapses 12 months after the minister increasing the VAT by an announcement in the budget is the minister's power to keep charging the higher rate. So the increased rate remains for 12 months, but if Parliament doesn't approve, that doesn't pass legislation making that permanent, what lapses is only that the higher increase cannot continue beyond 12 months. But every rent collected in the intervening year, the 12 months, stays in the National Revenue Fund. For the person who paid it, nothing about the tax is temporary. For the consumer, the tax is not temporary. And you can think about yourselves at the supermarket. If on every purchase you make for a whole year, you pay 0.5% more VAT, your grocery bill is much higher. It adds up very quickly. That difference matters far more for those who are already living below or at the poverty line. That's the first point about temporary and short term. The second is what is adjusted is the proportion of every purchase by every person in South Africa that goes to the state. On the minister's own evidence, a 0.5 percentage point alteration is material enough to fund budgeted national expenditure and to avert what he describes as a permanent shortfall that undermines the fiscal framework. So the respondents cannot describe the power as modest and simultaneously as indispensable. And the impact on the consumer is nothing other than modest. Third, merely characterizing delegating a power to make adjustment to rate to suggest that is severable from the imposition of the tax is not correct. Far from what SARS and the minister say, the choice of a tax rate is inextricably linked to the imposition of the tax. One does not impose a tax without a rate, and there would be no tax if no rate was set. Calling it temporary or short-term ignores the reality of the power on the public and its permanent effect. Thus, we submit attempting to draw a distinction between Parliament imposing a type of tax, creating the initial tax, and the setting of the rate at which that tax is payable is a wrong distinction to make. And the argument they make is that one can separate the imposition of a tax from its rate, and the Constitution only reserves the imposition of new types of taxes for Parliament, not the setting of the rate of the tax. We submit that the argument fails on both legs. Firstly, the argument is based on an artificial analysis. The tax rate is the defining feature of the tax. That is precisely what the Canadian Supreme Court held in Oecta versus Ontario, which is a judgment raised by both parties, where the court said at 520, a tax is not imposed until the rate is set. That is because along with the tax base and time unit, the tax rate is a defining feature of a tax. This must be the case, for if the rate is zero, there is no tax. That's the first point we make. The second is that to change the rate of tax is to change the tax itself. It determines the extent of the tax, with an increase imposing an additional tax burden and raising additional tax in the amounts that the consumers forfeit to the revenue. To confer power to change the rate of tax is to confer the taxing power, and we submit that this is consistent with the wording of Section 77 of the Constitution and not with the distinction that our learned friends seek to draw. Section 77 makes it clear that a bill is a money bill if it abolishes or reduces or grants exemptions from any national taxes, levies, duties, or surcharges. So when you reduce a tax, which is a power given to the minister, you're performing what is envisaged by the Constitution as to be regulated by a money bill. And when you are raising taxes, you're imposing additional taxes to the consumer, which is precisely what the section also deals with. And subsection, that was read from 77.1 and 77.2 reconfirms that by saying what the money bill must deal with, and amongst others is what I read. So on the respondent's own case, the power extends to abolishing the tax because Section 7 7.4 permits an alteration to 0, at which point nothing is payable at all. Now, there's no limitation in the section as to the extent to which the minister can reduce or increase the tax. So potentially he could reduce to 0, which means effectively abolishing the tax. So we submit on this analysis that the constitutional rule that applies once a charge is a tax applies to section 74, and we tend to identify in that rule which has been set out in the case law. And we say that the court's jurisprudence has embraced a bright line rule that once a charge is properly characterized as a tax, it cannot be exercised by anybody than the legislature, to the executive, for instance. We get criticized that we have our analysis of the judgments is fallacious because those judgments were concerned only with the power to create a tax. But you will not find in those judgments that limitation of the power that is debated as the power to create a new tax. It is a power to exercise, it's a taxing power, to put it like that. And Fetshaw is the first case that we have referred to, which was decided under the interim constitution, and it said under paragraph 44 and 45 that under the interim constitution, as under many other constitutions, the power of taxation and appropriation of government funds is reserved for legislatures. And in 45, it seems plain that when a legislature, whether national, provincial, local, exercises the power to raise taxes, it is a power peculiar to elected legislative bodies. It is a power that is exercised by democratically elected representatives after due deliberation. And we say that the section 7.4 gets that back to front because the due deliberation takes effect after the tax is imposed and collected and not before. Second is the Shuttleworth judgment, which concerned an exit charge imposed under the exchange control regulations by the executive. And the entire debate in the case turned on whether it was a tax or regulatory charge. And the debate was important because a tax could not be imposed by the executive. If it was a regulatory charge, it would have been permissible, subject to all constraints regarding delegations of powers. And at paragraph 42, Moseneke DCJ said this: a blissful starting point would be to affirm that the power to tax, it is the power to tax residents, is an incident of and subservient to the representative democracy. The manner and the extent, it's important the extent, when you increase, you're affecting the extent to which national taxes are raised and appropriated must yield to the democratic will as expressed in law. Duly elected representatives who decide on the taxes that residents must pay. An executive government may not impose a tax burden. When you're increasing the tax burden on the consumer, or appropriate public money without due and express consent of elected public representatives. And I repeat Fetshaw, and at the end of that paragraph, it is plain that in our jurisdiction, a decision or law that purports to impose a tax will be invalid to the extent of its inconsistency with the limits imposed by the Constitution or other law. That's also a bright line test, and the test for determining whether it's a tax or a regulatory charge is a dominant purpose test. That's addressed 48 to 52 in Shuttleworth. But for our purposes, because that debate was directed at characterization, here it's common cause, this is a tax, we don't have to engage in the characterization. New Africa, again, the issue there was whether the power to amend schedules to the Customs Act. The minister did so to curb abuse of diplomatic duty-free immunity, and the court had to determine whether that was a tax or a regulatory charge, and the majority concluded that the power in issue is regulatory in nature and not a taxing power. It was that finding we submit which took the case out of Section 77 of the Constitution, and therefore we submit New Africa confirms the rule that revenue raising is for the legislature. Conduct regulation may be delegated to the executive, subject to the context-specific test in that case. Had it found that the power was a taxing power, the conclusion may have been different. It didn't reach there, the minority did, but that was not the majority's determination. In casino association, again, a holder of a license, the provincial legislation provided that a holder of a license shall be liable to, at such intervals as may be prescribed, pay a gambling levy which shall be calculated on such basis and at such rate as may be prescribed, and be payable in the manner and before the date as prescribed, provided that different rates may be prescribed in respect of different types of licenses. The levy was imposed in the body of the statute because it said the levy will be paid. But the court, what was delegated was the power to determine the intervals, prescribe the rates, and the basis for calculating. And the court affirmed at paragraph 42 that it is settled that the power of taxation and appropriation of government funds are reserved for legislatures and that the executive has no power to raise taxes itself, is the power to tax. And that the dominant purpose there was clearly tax, paragraph 62, and the founding was without more sufficient to declare the provision invalid. That was a bright line rule without the application of a balancing exercise, which would be the New Africa approach. And SARS and the minister argue that that case is different because until the minister prescribed a rate, there was no tax. But there was in section 87.1, and the court will see that at paragraph 14 of the judgment, that the legislation itself said a holder of a license shall be liable to pay a gambling levy. What was left out was the determination of the intervals, the rate, and the base for calculation. So we submit that the statute itself imposed the levy and fixed liability for it, and what it delegated is what I just submitted. And that the court held it was not permissible to delegate that power to the executive or anybody else. Motlhaba, again, concluded in the same way, that a power to tax may not be delegated to a traditional council, and the court said at paragraph 17, this court has repeatedly held that there must be a direct constitutional source for the power to impose a tax. The Constitution only affords a taxing power to the three elected spheres, and the power to tax cannot be delegated to the executive. Paragraph 17, that's the judgment itself. And the Constitution reserves the taxing power for legislative bodies, and that when it permits the imposition of tax, it does so expressly and regulates how the power must be exercised. Legislative bodies can delegate the power, can delegate the power to regulate, but not the power to tax. That's paragraph 20 of that judgment. And so we submit that there is no distinction here in real terms between what the minister is, the power that delegated to the minister and the power to tax, because it is precisely the power that defines the tax, which is delegated to the minister. And in paragraph 25 of the judgment in Motlhaba, this court held the provision invalid because it delegated a taxing power both to the council and to the premier. And it reaffirmed the statements of principle in Fetshaw, Shuttleworth, and Casino Association. And we submit that if one applies the common cause facts to the principles to the common cause facts, the delegation is invalid because this was a delegation of a taxing power, and that is inconsistent with the principle, also inconsistent with Section 77 of the Constitution. I turn to the New Africa test, and we submit the New Africa test on the assumption that the court takes the approach of the High Court, that even if this is, the High Court accepted that setting a rate is essential feature of the power to tax, but said it is subject to the context-specific assessment in New Africa, which refers to the scope of delegation, the degree of delegation, the subject matter of which it relates, a sufficiency of constraints and the like. We do submit principally on our first argument that that would be wrong, but if the court is against us. The first issue I must address is the procedural issue which is raised by both parties, which is that this was not the DA's case. It didn't plead the New Africa assessment. We submit first that there are a number of reasons why we submit this objection shouldn't stand. Firstly, what must be pleaded is the ground on which the statute is said to be unconstitutional. And here, Section 7.4, we submit, alleged, unconstitutionally confers on the executive the power to tax and the power to amend the Act. And that was at paragraphs 18.10 to 18.11, 104 to 105, and 39 to 40 of the founding affidavit. That grant never changed. What is in issue is the legal test by which the grant is to be assessed. all the complaints about the impact of Section 7.4, which are relevant to the New Africa factors, are raised in the founding or supplementary founding affidavits, as the High Court found. They are just not labeled New Africa factors. Second ground on which this must not be accepted is that the multi-factor test is the respondent's answer. It doesn't have to be the DA's cause of action. The DA's case is that the delegation is unconstitutional. The respondent's answer is that it constitutionally depends on a contextual weighing, and in advancing that answer, the respondents filed extensive affidavits addressing inter alia the budget cycle, the need for speedy action, legislative timelines, revenue forecasting, and the consequences of a shortfall. And you will find in the Minister, paragraphs 20 to 40, in volume 4 dealing with Part A, and also in volume 8 dealing with Part B at paragraphs 31 to 53, and SARS does the same in volume 8 at paragraphs 15 to 19, 48, 54, 101 to 105. Those are their defenses. And it is right that they raise those defenses, because even New Africa starts off at paragraph 77 by saying that the delegation of plenary powers is likely to be generally unconstitutional. So that's the proposition that the DA puts up. In answer, they say, no, there are constraints which justify the delegation along the lines of New Africa. And if the court says that is the proper test, of course the court then applies that test on the facts pleaded to determine whether they are correct or not. A third point we make is that the authorities that the respondents rely on relate to new grounds of attack and not new argument based on the same facts that are pleaded. In Savoy, the applicants raised for the first time in written submissions a distinct ground of invalidity. DV Behuising, the new complaint was that a repeal interfered with existing property rights, a wholly different constitutional complaint from the competence point pleaded. Teletsani concerned genuine factual disputes. Fourth ground is that the inquiry is objective and is a question of law. The constitutionality of a statutory provision is an objective question, and we refer to O'Brien versus Minister of Defense at paragraphs 56. Each of the 4 New Africa factors is directed at the statute, the scope of the power conferred, its subject matter, its degree, and the constraints upon it, and each is centered by an objective assessment as a legal matter of the provisions of the section. Sixth, the Minister expressly reserved the right to say more in Part A, in his answer to Part A, and he addressed each factor and said he would respond more fully at the appropriate time if necessary. You will find that at volume 4 at paragraph 54, is page 282 to 6. He then filed a supplementary answering affidavit in Part B and said he didn't see the need to do so. And seventh point is that none of these respondents identify a single fact that would have been placed before the court had the ground been pleaded differently. There is a direct precedent, and there's a direct precedent here in New Africa itself, and the court can have regard to paragraphs 22, 29 to 34 of the judgment. The case was pleaded and argued on the basis that this was a bright line rule against the delegation of plenary legislative powers, and this court didn't dismiss the challenge merely because the High Court, New Africa wasn't pleaded. Just again to conclude, on the Minister's side, the Minister acknowledges that in Part A, the DA in reply engaged with the factors under New Africa and said those factors still supported a conclusion that the delegation was invalid. And I just for now can't find the reference to their heads where they make the concession, but it is there, and it is it is correct that is stated in the replying affidavit by the DA. You will find the replying affidavit at paragraph 322 of volume 5, and the very last paragraph deals with those factors. The SARS, on the other hand, raises the reply but doesn't reference that paragraph. That paragraph gave all of the respondents notice that the argument was even the factors don't save the legislation. Finally, this court has a judgment which applied New Africa. If the court were to find that the confirmation must be dismissed because the two bright lines are dismissed and New Africa was not pleaded, that judgment remains in limbo. But secondly, the DA would then be entitled to go back to the High Court, run a New Africa case on this judgment, and come back here to the court, when in fact at this point there's no one saying there are additional points, facts to plead. So we submit that the issue squarely arises before this court as a matter of law, and there is a judgment that the court must determine. Now we turn to the factors, the scope of the delegation. The delegation, the scope, the increase in 7.4 is immediate and irreversible. It lapses after a year without Parliament's approval, but during that year, everyone has to pay more taxes if the rate has increased. It's no answer to say that the scope is extremely narrow because it applies to a single element of the tax system. The rate element determines the entire yield of the tax and the entire burden on the taxpayer. A power confined to the rate is a power over everything that matters about the tax. And everybody pays that tax on every transaction that is applicable. The VAT Act itself places no limit on the direction or magnitude of the alteration. Contrary to some of the jurisdictions that have been relied upon, the minister determines both the rate and the date from which it operates, and it imposes no obligations at all that would trigger the power. The scope of the delegation we submit is significant. The subject matter is the power to tax. As the High Court said, that highlights the intensity with which this court must scrutinize the safeguards. I'll stop there because that's the ring, and I'll address the rest of the factors in questions, if there are questions.
What relief do you seek?
We ask that the confirmation of invalidity be granted, and we ask that there is no reason to suspend the declaration of invalidity, but we don't put our necks on the block and die by that. If the court finds that the act is invalid and there is a reason to suspend the declaration for 24 months to allow the Parliament to fix the remedy, we do not believe that the minister would, in the light of this court judgment, carry on implementing that provision in the way as it currently stands without getting parliamentary intervention. That's the relief we seek.
Thank you, Mr. Manager.
Chief Justice.
Mr. Manager, am I correct if I say that the issue really is whether the amendment to the rate of VAT constitute the imposition of tax, and in particular also have regard to, because the argument is that if you look at section 77, is it covered, the increment of a rate of VAT? In other words, when you talk about imposing that rate, would that be covered under that section?
Yes. So, yes and no. I'll start with the no. The case law that I referred to characterize the power which is reserved for the legislature as the power to tax. That is, it doesn't say it is the power to create the initial tax. In other words, to create and impose the tax initially. It simply covers all incidents which are material enough to affect the taxing power. And on our submission, determining the tax rate determines the amount of tax that's going to be collected to individuals, which is precisely why you have representative democracy, because that is so an intrusive a power which determines how much we're going to keep in our pockets and how much is yielded to the revenue, to the government. So that's our first answer to that. But if the court were to find that when you read section 77, you must characterize the power as imposing a tax or reducing a tax, we would submit that imposing a tax is broad enough, given a constitutional meaning, to include the power to add the tax, to collect additional tax. You're imposing an additional tax burden. And that is the language that Shuttleworth uses, Justice, the former DCJ used, Moseneke used in that it is about raising taxes, it is about the extent of the burden, the tax burden that you are determining for consumers, for taxpayers. And that is precisely what the power to adjust the rate does. When it goes up, more money is collected from our pockets. If it goes down, less money is collected from our pockets. And a reduction, it's specifically mentioned in Section 77. And very much like the argument our learned friends make that if the minister can announce and introduce, the minister can withdraw. Reduction would, by implication, presuppose that you can have an increase. It would work both ways. So we submit that the power delegated in 7.4 falls squarely within both the case law and Section 77 of the Constitution. And on the bright line rule, we say it is unlawful for that reason.
SARS points us to a number of provisions, legislative provisions, where they say they are similar to Section 7.4. And in those provisions, it is a practice to permit the executive to determine the rate of tax. What do you make of that argument?
Yes. So the first answer is some of those relate to what would be regulatory charges. So they wouldn't implicate our first submission, and they wouldn't implicate the intensity with which one assesses the balancing exercise in New Africa. So they might be a different class, very much similar to what New Africa was dealing with, which are regulatory charges. To the extent that they are taxes, there is a fundamental difference if you're dealing with income tax. As we submitted, in the case of income tax, the minister announces that there will be an increase of personal income tax, or whatever category of tax, in the budget speech. But the tax is only imposed and collected when the legislature passes legislation and is collected retrospectively. And the reason for that is that income tax is paid at assessment. At the point of assessment, there will be a law by Parliament. So it's possible that if one was challenging an income tax-like provision, that there might be an initial argument about who actually imposes the tax. Is it the minister or is it the legislature, where the tax doesn't take effect, the collection doesn't happen until there is legislation which warrants the deduction of the tax. So there could be differences, and that's why in our heads we've said each case would be determined on its own circumstances. If there was a particular challenge to a provision that is taken to delegate a taxing power, that will be considered on its own. VAT is immediate, is collected immediately, and is never reversible. So it's both legally irreversible and is factually irreversible. It's legally irreversible because Parliament can't reverse the effect during the 12 months of an increase. It can only affect whether post the 12 months that increased rate continues to apply. And as far as the consumer is concerned, it can't be recovered. So factually, it's lost to the revenue. It is the twin argument of what they say: if we don't charge a transaction, it is lost to government. It is correct, but it is not a virtuous SARS one to suggest that because they have to collect a transaction, then they can't wait for government, for parliamentary resolution or approval by way of legislation. They must collect now. But they ignore the impact on the consumer, on the poor or rich consumer, that it is an indiscriminate, non-progressive tax which you then have to pay on each consumption, each service of a good or a service, and you cannot reverse it. So the power is hugely invasive in relation to the consumer.
So when they say the adjustment is temporary and lapses after 12 months, they are not correct, because the consumer would have paid, and the consumer won't be able to recover whatever if Parliament decides to change whatever rate that had been imposed by the minister.
Yes, so as we understand the argument, and we mustn't mischaracterize what they say, it's temporary in the temporal sense, that for 12 months, it only subsists for 12 months. But its effects, as Justice Mkantla raised with me, its effects are permanent to the consumer because you never recover it. And it's a 12-month, 12 months in the life of some people is very short, but there are many of our consumers out there for whom an increased price on goods for 12 months is significant. And they have the protection in the Constitution that those kinds of decisions will be taken by their representatives in Parliament, taking account of all relevant factors and not simply looking at whether we have other alternatives to close a loophole in the expenditure revenue determination by the minister. Thank you, Justice Mkantla.
Mr. Manager, does the DA contend for an absolutist approach? And if yes, and if no, why?
Yes. We thought Justice Matopo will raise that question. So, in relation to the taxing power, we persist in the absolutist approach, that rule is absolute. If it is a taxing power, it cannot be delegated. But if that is rejected, then we are in New Africa, we accept. I come to the plenary powers. The reason I was so quick to identify the taxing power point is that in plenary we have to contend with the judgments of this court and see whether we are right that there is a rule that survives which says that the legislature cannot delegate plenary powers. So as we understand it, from Executive Council, a bright rule was established by the majority that one can't, and that is in paragraph 62 of that judgment, where the court said there was a difference between delegating authority to make subordinate legislation within the framework of a statute under which the delegation is made and assigning plenary legislative power to another body. At paragraph 62, the court said, it is a necessary implication of the Constitution that Parliament should have the power to delegate subordinate legislative powers to the executive. To do so, it is not inconsistent with the Constitution. On the contrary, it is necessary to give efficacy to the primary legislative power that Parliament enjoys. But to delegate to the executive the power to amend or repeal acts of Parliament is quite different. To hold that such power exists by necessary implication from the terms of the Constitution could be subversive of the manner and form provisions of sections 59, 60, and 61. And it referred to those powers as plenary, the power to amend. And then it said at 62, it acknowledged that there may be exceptional circumstances such as war and emergencies in which there may be a necessary implication that laws can be made without following the formal procedures.
I want you to get there
Yes.
and have a debate.
Yes.
Exactly where the war starts.
Yes. Justice Matopo. So the way we...
I'm talking about the economic war.
The economic war. Yes, there's a different kind of war, but yes, Justice Matopo, you're quite right. And we had COVID, which was another war.
Yes.
The way we understand the distinction between the majority in Executive Council and the minority is the minority, Mohammed DP then said, it is a balancing exercise. So you look at the factors which are now embraced in New Africa to determine whether the delegation is valid or invalid. The majority said, it's good to know that there may be other factors, but they are irrelevant if the legislature simply doesn't have the power to delegate. So it didn't engage the balancing exercise. So we see a distinction between the exception of war and emergencies versus the balancing exercise. That one might see the exception, and I'm borrowing from my able fellow counsel here. One might see the exception conceptually as a tree, or pictorially, I don't know what the right English is, and the balancing the New Africa exercise as a basket. So in the basket, you throw in all the factors and you say, is the delegation nevertheless justifiable? But under the tree, you have a fixed rule, then you have exceptions, which could be the branches. And so we see Executive Council as setting a bright line, but saying there could be exceptions. But that is different from context specific. But if we are wrong, of course, if the court says the exceptions connote the same thing as the balancing exercise, they're creating a context-specific evaluation, then our analysis would flounder from there. And if we fail there, then the rest of what I'm going to say will probably fail.
But
So
why would the context-specific exercise not be an attractive option to consider? One, if you are to interpret the impugn section, isn't it correct that you have to interpret it in terms of the triad? You look at the text, the context, as well as the purpose. And that in itself, if that exercise would entail a context-specific exercise, and if you bring that into the context, would it be correct then to say, you look at the conduct of the minister, why the minister decided that we had to have this increase. The increase, if the minister had waited for the increase, what dire consequences would the country have had? In other words, the minister would have had to go out and borrow. Isn't one required to understand and read the section or the powers of the minister? He's not amending the VAT Act. He's not advocating for its amendment. All what he's saying, to deal with these exigencies that is confronting the country, we have to come with, as in the COVID, interim relief measures that will deal with the context in which the country finds itself in. And he says, this is not, I'm not legislating, this is a temporary measure. And being a temporary measure, it is subject to parliamentary control or oversight. Why is that problematic?
yes. So I must address the first point about the triad of text.
The text,
Purpose
context,
and
and purpose.
context, yes.
When you do that, consider also section 7 subsection 1. They have to be read in conjunction or in comparison with each other.
Yes. So the first submission to make is that the triad of text, context, and purpose, which is the interpretive exercise, that the court engages in to determine what the section means. You determine the meaning of the section. Once, and as we submit, once you've determined the meaning, and 7.4, the meaning we assign to it is that it allows the minister to alter the rate in 7.1 and to do so without parliamentary intervention, and that for the period of 12 months, that altered rate applies irrespective of whether Parliament approves or doesn't approve. The only change that comes about is to the rate is after 12 months, if Parliament in the 12 months doesn't approve of that rate, doesn't pass legislation approving the rate. So we fix the meaning, but that is where text, context, and purpose function. That's what it does. It helps us determine the meaning. Having determined the meaning, then the next question, which Justice Matopo asks is, does it amend the provision? If it does, we submit that it does, because for the 12 months, the rate that applies is the rate determined by the minister. There's no doubt about that. And is not the rate determined in 7.1. So that rate in 7.1 doesn't apply alongside the rate in 7.4. The 7.4 rate applies, it's altered. 7.1 has been altered. And that's to alter effectively what that section provides, that section fixes. And we submit that that is a classic power of amendment. You're changing what a section of an act provides. and you're saying for the 12 months, it will be at this rate. As I submitted already, it's for 12 months, it's guaranteed without parliamentary intervention. It's only post that Parliament's intervention affects. Then the third question that arises from my submission that there is an amendment is there a bright rule that the exercise of that amendment power breaches? And that's the question Justice Matopo asked. Is there a bright rule in our law which says a Parliament cannot delegate a power to amend a statute to the executive? Whether one is talking about the body of the statute or schedules as in Smith, this court said the schedules are as much the part of the statute. Let's assume that's the point of departure. Then the question is there a bright rule that is breached? If we are right that there has been a bright rule in Executive Council applied in Smith, and what New Africa did was to distinguish that case from Executive Council and Smith, but not to overrule Executive Council and Smith, then that would mean that the bright rule is still part of our law. And then the plenary power argument would succeed. But if the court is, and we say this very respectfully, that we don't suggest that we have identified the proper distinction that the court drew in New Africa between New Africa and Executive Council and Smith. Our understanding, and we've discussed this, and I have much more brighter people on my team, we understand Executive Council, New Africa to say, to start off at 77, generally delegating plenary powers are likely to be unconstitutional. But on the conception of separation of powers, maybe there isn't a rigid rule. But that the case itself is not decided on the basis that what was delegated was plenary powers. What we understand the court to say, it's regulatory powers, and here I must refer to the judgment to why the suggestion is made that there is a distinction and the way we understand the distinction. If I can take the court to paragraph 91 and 92 of that judgment. And I just want to summarize where I'm going, is that we understand ultimately the court to have characterized the power not as plenary, and it used the words primary or original legislative powers. It said it's not that kind of power that's being exercised here. It's a regulatory power, and that can be delegated, and then said, here are the factors we considered, it is justified. And in paragraph 91, the court distinguishes, the court identifies what was said in Executive Council. It says, in Executive Council, the President was required to submit the proclamation to Parliament within 14 days. Section 16, capital A, prescribed that if Parliament by resolution disapproved of the proclamation, then it ceased to be of force or effect. However, if Parliament did nothing in terms of Section 16A, the proclamation would remain law. This is different from what Parliament can do in terms of 48(6) of the Customs Act. The latter provision effectively mandates or compels parliamentary involvement. It states that if Parliament does not intervene, then there is an automatic lapse of the amendment to the schedule. If the amendment is to have longevity, Parliament's involvement is imperative. In Duriek, this court noted that schedules to any statute are inseparable from those statutes. Therefore, as schedules form part and parcel of a statute, an amendment by the minister to the schedules would not qualify as the exercise of subordinate legislative powers. Smith, upon which New Africa also relied, concerns Section 63 of the Drugs Act. In Smith, the applicant, in challenging the constitutional validity of Section 63 of the Drugs Act, argued that to the extent that Section 63 delegated plenary legislative power to the minister, it was inconsistent with the Constitution. Section 63 empowered the Minister of Justice in consultation with the Minister of Health to amend Schedules 1 and 2 to the Drugs Act. This court found that when the minister decided to amend Sections 1 and 2 to the Drugs Act by including or delegating a substance, he or she was in fact amending the Act itself. Thus, Section 63 conferred on the minister plenary legislative power to amend the schedules. As the schedules are essentially part and parcel of the Act, Section 63 in effect delegated to original plenary legislative power to amend the Act itself. This was held to be constitutionally impermissible. 92. A closer look at 7515 of the Customs Act indicates that it empowers the minister to amend schedules to the Customs Act whenever he deems it expedient in the public interest. The caveat is that the minister's power must be rational, lawful, and pursuant to the purpose of the legislation. Kenna Systems supports the Commissioner's contention that when the minister amends schedules to the Act, he is not exercising primary or original legislative powers. It's unclear whether the Court says, I agree, but there's an implicit agreement in that. Then it says at 94, and I'm skipping 93, at 94, I agree with the Minister and the Commissioner that Smith is distinguishable. The fallacy in New Africa's submission is that it would render every statute that permits a member of the executive to amend a schedule unconstitutional without due regard to the nature, extent, and scope of the delegation, or indeed the relevant factors laid down by Mohammed DP in Executive Council. So the Court is borrowing from the minority in Executive Council. And it says this absolutist approach is at odds with the rationale of this Court in Executive Council, where it was said, there is nothing in the Constitution which prohibits Parliament from delegating subordinate regulatory authority to other bodies. The power to do so is necessary for effective lawmaking. So it is justifying its approach by reference to an uncontroversial proposition that the power to regulate can be delegated, which is commonplace, is agreed. And so when the Court returns again at paragraph 102 in conclusion and says, at 101, it then deals with the factors and says it holds the delegation to be permissible. And at paragraph 102, to conclude, Smith and Executive Council are clearly distinguishable from the present matter before this Court. Considering their aforesaid factors, it cannot be said that Parliament's delegation in respect of the Customs Act and the VAT Act is constitutionally impermissible. So we understand it to mean the Court accepted the argument that this is really regulatory powers that can be delegated subject to a context-specific assessment. We are not overruling Executive Council and Smith to the extent that they said there is a bright line in respect of powers to amend the body of a statute.
Okay, let me finish my installment. On the Section 77, the money bill, there is a minority view by my brother Rogers on that particular point. What is your submission to that?
Yes. So Justice Rogers had to reach Section 77 because he differed with the majority that this was not he said it wasn't a regulatory charge, it was a tax. And once it was a tax, he was met with the argument that, but then the delegated power breaches Section 77 because the minister cannot act in compliance with Section 77. And what Justice Rogers said is, well, that argument is fallacious, is wrong, because it hangs on the proposition that the delegation is invalid because it breaches the manner and form provisions of the Constitution. And he said, well, that would apply to every delegation, because every time a minister is delegated, they are entitled to, they are not bound to follow the manner and form provisions of from 73 to 77. But that was that minority judgment we submit stands in stark contrast with the finding by the President of the Constitutional Court, Chaskalson, in Executive Council, the paragraph I read to, that insisting on compliance with the manner and form provisions of the Constitution is constitutionally required. And if you want to depart from that, you must change the Constitution. So that minority judgment, with respect, can have the effect of overruling Executive Council. And we respectfully submit that for that reason it is wrong, because the Constitution requires the compliance with the manner and form provisions. Otherwise, it means that the Parliament can delegate to the minister to do that which it cannot do because it can't do so in breach of Section 77.
If the minister had acted as the minister did in New Africa with the schedules, would you still be making the same point today?
And I don't profess exactitude here. My understanding of the New Africa power was that it wasn't a power to determine a rate of VAT. It was about exemptions and the like to deal with conduct. So it didn't address the question of changing the VAT. If it had been put in a schedule,
No, there was no VAT there.
there was no VAT. No, there
Yeah,
was no.
it was the customs.
There was a
and
reference
excise.
to in the reasoning. There is a reference to Section 7.4 as one of those practical provisions to allow for the collection of taxes in advance, which can't be collected retroactively. But it wasn't grappling with what this court is called upon to grapple. But here's my submission: is that even if Section 7.4 had been put in a schedule, on our submission, because it allows an amendment of Section 7.1 effectively, in substance, by altering the rate prescribed by Section 7.1, you would end up in Smith, because it would be changing the body of an act, and you would still be faced with our plenary PowerPoint. And contextually, it wouldn't make a difference, because the nature of the power would still be a relevant factor, that it allows for a change prescribed in a statute, in the body of a statute, and it allows for that change to happen immediately without Parliament intervention and to be irreversible by Parliament.
All right, thank you.
Mr. Maineche, I'd like to ask you about the relief that the applicants seek, please. The applicants raise a conditional appeal against paragraph 2 and 4 of the High Court order. In paragraph 2, the High Court suspended the declaration of invalidity for a period of 24 months to allow Parliament to correct the defect. The proposed alternative remedy is that the declaration of invalidity operates from 1 March 2025. Is that right?
Yes. So our alternative is to declare that it won't apply retrospectively or only applies prospectively, because we don't want to undo anything that was done under Section 7.4.
Now, the Minister announced the budget speech on 12 March 2025, with the increase set to take effect on 1 May 2025. And what is the harm that will be endured if the suspension of invalidity operates prospectively?
There will be no harm. Yes. Other than that, he would have retained the unconstitutional power for that period. There is no direct harm that I can point to, because the tax wasn't collected. There was a bill was passed, and that was the tax was the increase was withdrawn.
In paragraph 4 of the notice of motion, the applicant appeals the declaratory order that the Minister's decision on 12 March 2025 was unconstitutional and invalid and should be reviewed and set aside. Is the ground of appeal there that the High Court erred in holding that the Minister had the implied power to withdraw a decision made in terms of Section 7.4? I'm struggling to understand.
That was initial, but we don't pursue.
I think your junior would like a word.
We don't pursue that.
Whilst to frame your answer,
Sorry. I was referred to the court, the order of this court, but we don't persist in seeking that. In that, I thought we might have mentioned it in our heads, but I'll stand corrected. But we don't persist in that. in seeking an appeal against that dismissal of that declaration relief, of that declaratory relief.
Thank you, Mr. Manager.
Thank you, Justice Toro.
I was just going to ask you, Mr. Manager, although it may be a little late in the day, that you have your juniors take us through the case lines references whenever.
Oh, yes. I was promised that, but I probably...
No, well, I don't, maybe it's just me and Justice Theron, but we have not been taken through any references at all.
I really beg the court's pardon. Can I give the references that I gave to the court on the affidavits and give the case
It's not
line
necessary.
references?
We'll leave, but just a word of caution to the
To the others?
respondents.
Yes. Yeah, they will bear that in mind. That's the fortunes of starting first. Yes.
Thank you, Mr. Manager. Just following up from the questions from my colleague Justice Matopo, while paragraph 77 of New Africa suggests that, well, let's read it accurately, if the delegated power is plenary in nature, it's more likely to be constitutionally impermissible than if it is merely regulatory. That case didn't deal with delegation of plenary power, correct?
Yes, that's,
Right.
that's how we understand the
Okay,
court
good. Sure.
settled on. So it doesn't answer the question,
Sure.
the question you have to answer.
Good. And in paragraph 95 of New Africa, the court then said in broader terms, whether a delegation constitutes an affront to the Constitution is a context-specific inquiry, not so.
Yes.
And so that seems to suggest that the nature of the power is not dispositive. May well be likely, but it's... And if one answers the question whether it's absolute in the negative, then we get into the balancing exercise and the factors, correct?
Yes.
And what would you say about the argument that the Constitution has to be interpreted in a manner that ultimately redounds to the benefit of South Africans? That if the power that is delegated is really to allow for what you might call a rapid intervention, and in the era of globalization, someone sneezes in Switzerland, it could affect the South African economy. That under those circumstances, given that section, given certainly that the Constitution, as well as the manner in which that has been interpreted by our courts, doesn't point clearly to an absolutist position, that in that balancing exercise, one must take into account precisely that context. The limited duration of the power, Parliament continues to retain control, and a number of those factors. What would you say to those two propositions, that it's not absolute, and that if one has regard to those factors, that New Africa points us to a conclusion, one different from that of the High Court, is more aligned to the Constitution?
Yes. Justice Kolopin, I must just start by correcting what will be, I know my learned friends are very respectful, but they'll probably say I made a fatal concession. When Justice Kolopin took me from paragraph 7795, and I accepted that New Africa didn't deal with plenary powers, by that I meant that it wasn't grappling with the absolutist rule in relation to plenary powers, and was dealing with, in the context of regulatory powers, it is context specific, and I accept that. We don't say that.
That recognition is good enough for me.
Yes, yeah, Justice Kolopin, I guess so, but I just wanted to be certain. So it is correct that the interpretation and the balancing must give effect to the Constitution. And there are two competing interests in the Constitution here to be balanced. The one is what they've raised, the need for rapid responses in the public interest. On the other hand, there's also a need for the public representatives to exercise the taxing power in the public interest. And when you're looking at the balancing exercise, one asks the question, you'll ask the question whether Section 7.4 gets the balance right, so that both of those constitutional values are not compromised. Now, there are very good examples in the foreign jurisdictions which have been referred to by both parties. There's a class of jurisdictions which don't give the power at all, and there are a number of them, including Australia. Let me just go to my notes on foreign, just so that I give the court the proper reference in our heads. So we deal with that. In our heads, the court will find at paragraphs 136 to 137.2 a discussion of the jurisdictions that do not give this common of power: Canada, New Zealand, Australia, Germany, and Colombia. There was a little bit of criticism against us for referring to New Zealand, because there's a power given to the DALE, which is a committee of parliament which can approve this kind of increase, but that's the parliament again. But those countries do not give at all this power. That answers one proposition, that this power is indispensable. It shows you that there are open democracies comparable to our own which do not regard it as indispensable. And can I say, the facts of this case demonstrate that it is not always necessary, because here we were promised the heavens would fall if the power is not exercised. And when there was pushback by Parliament and ultimately a withdrawal, an alternative funding mechanism was devised to close the gap, whether it's fully closed or not fully closed. But the point is, fiscal management requires also strong checks by the legislature to ensure that the executive does everything possible to fund potential expenditure from other sources before they readily go to taxing all of us who are already heavily taxed. Maybe I'm a bad example, but my grandparents and mothers who are in the villages would be seriously affected by this, the only relief being the zero rating of products. So there are those countries. Then there are the countries that provide for this kind of power. Those countries we deal with also in our heads at paragraph 138. They include the United Kingdom, they include Kenya, they include Botswana, they include Ireland. And what is notable by the provisions in those countries is that they impose, without undermining the need for speed. I always chuckle because this is a game, computer game for youngsters, Need for Speed. But without compromising need for speed, they regulate the extent of the change, down or up, of the tax, and they regulate, sometimes require that the proposed increase must be laid before Parliament or House of Parliament within a short period of time, sometimes 20 days, sometimes 30 days, and the like, to seek the approval of Parliament prior to the increase kicking in. And that is simply by resolution. It's not by passing legislation, which they say takes long. It's simply by resolution. So if they say no, the provision never takes long. And because it is Parliament that budgets, it is Parliament that expends money, it is Parliament that determines where the money must come from. It is not the executive. The executive plans and makes proposals. Because it is Parliament, when it says no, when you come in 20 days, you can't do this, there will be a debate in Parliament about what other potential sources are
Mr.
there.
Manager, I accept in other jurisdictions the oversight period is...
So ultimately our submission is this provision gives that power in very unconstrained and wide terms that allows the minister to go up and down whichever he wants. Of course he must act rationally, but rationality is an after-the-fact control, is not a before-the-fact control. Before, he can act either way, and in 12 months, that takes effect. So it's an exceptional case, but he can reduce to zero, or he can increase by a big amount. And that's important, because that Parliament can regulate, can provide a cap, can provide
Okay.
for a resolution. And that's what Parliament can still do if this court agrees with us that if the court finds that a context-specific assessment applies, but like the High Court upholds the challenge that even that doesn't pass muster, then Parliament has all the wide scope to fix the problem that the court identifies.
Okay.
So that would be my submission.
Mr. Manager, you've indicated this wide power and need for some kind of certainty, but would you accept that sort of global finance, predicting what might happen to the global financial system, sometimes amounts to looking into a crystal ball, and therefore, would you accept that some degree of deference must be provided for in how these they may not materialize, as you said, the heavens did not descend upon us, but it could well have, and we would never know that. And to what extent must one at least defer to the expertise of others and to factor in the uncertainty of how those systems work?
Yes. I accept that there are certain changes in the global financial system. One can't look with a crystal ball. But as the Treasury explains, the Minister explains, this planning takes long, many years, many months, maybe close to a year in advance. And also, once decided, the increase is not implemented immediately. Often it's given a month, 2 months, because the vendors must adjust their systems to collect. And so the risks about conduct, tailoring, and all of that is inherent in the way the system works. So what I'm saying is it is not a tool that can be justified solely by if there's a sudden change in the world, you must respond, because itself has a lead time, and the announcement takes lead time. But also, it only happens once at the budget announcement. It's not during the year something has now changed in the world, there's a shortfall, you can go back and announce an increase. It's only once. So one mustn't over-exaggerate that speed of response, the speedy response. But it can, because of the lead-up and also the notice period that happens given to vendors, one can factor in the 20 days or 25 days or 30 days resolution by Parliament, at least involve Parliament. Because the deference one is talking about is not a deference by the court, it's a deference by the legislature, which has the power to tax. When it receives the plan, which has input of experts and the like, it may show deference, but sometimes it may be so clear that deference is not owed, because there are other alternatives, as happened here.
Okay.
And the executive does what it has to do.
Finally, just for my own ignorance, how does the fuel levy work? I mean, the minister can determine the fuel levy on a monthly basis, up and down.
Yes. Justice Colopin, I'm going to profess the same as Justice suggested about the fuel levy. I know that is subject of an attack in the Western Cape. I don't have the mechanics of how it works, but I understand that it does get adjusted up and down, but that too is being challenged. And I'm not sure whether that is a tax or regulatory charge. I'm not certain.
But as we speak, I mean, the fuel levy is to cushion consumers from unexpected increases in the fuel price internationally, but it's also used to fund the road accident fund. And one could say it's a tax in order to fund the road accident fund. Like VAT, once the fuel levy is paid at the pump, that's it. I mean, if in that month the fuel price internationally goes down, we don't get a refund on what we paid. How different is that from VAT? You might want to look at it, because it's something that just occurred to me now.
Yes, it did. Of course, it's fair that it occurred to Justice Colopin. I'm not certain that in whole it is a tax, and that's a matter that's been debated. But also whether it is wholly recoverable, or whether this is, and if there's any way of recovery, whether there's a way of identifying the people that paid and you can reverse.
On the example you gave, that it's impossible to identify who bought bread, it's impossible to identify who filled their car.
It sounds right. So it'll just be money back in the pockets of car owners if it is reduced. But there's a flexibility about the fuel levy which is different from the VAT here, that it is, I don't know whether the regularity is as regulated as here, where it can only be made once in a budget announcement, which itself allows room for engagement by the legislature, which may not be the case.
But the point is simply
with the fuel levy.
that in principle it provides for, if it's a tax, then it's a tax determined, the rate is determined by the minister.
Yes, and it provides relief. I think that's what Justice Colopin identified. Provides relief, but also may fund the RAF. The VAT, an increase only does one thing. It only collects more revenue, doesn't provide any relief. So
Except at the rate at which the Road Accident Fund is using the money, it may provide more pain than relief. But
that's
anyway,
absolutely right. And maybe that court is also looking at those kinds of things when it exercises, it conducts the balancing exercise. I'm just not sure. I'm not able to assist the court where the scales would fall if the case before the court was about the fuel levy. But I think I can at least confidently make submissions about the VAT.
Sure, I was just trying to find a paddle to this. Thank you, Mr. Manager.
Thanks, Justice Colopin.
Mr. Manyeke, I just would like to test the DA's position or understanding of what constitutes a plenary power, and I do that in the context of what was said in the Shuttleworth case. Now, the Shuttleworth case has said a lot, but there are two issues that stand out to me in the context of this matter. And the first one is no taxation without representation, and the principle that, and I'm reading from paragraph 42, an executive government may not impose a tax burden, etc., without due and express consent of the elected public representative. That is a principle that I think everyone accepts. But then the court says in paragraph 48, it says the seminal test is whether the primary or dominant purpose of the statute is to raise revenue or to regulate conduct. Now, as I understand the papers, the purpose of raising the VAT rate is to raise revenue, but you can help me if I'm wrong there. So does that then mean that if the VAT adjustment is labelled, and I hate the word labelled, but let's use it for convenience sake, is labelled a tax, that means it is a plenary power, and then it follows that it's something that may not be delegated. Is that an acceptable proposition, or what is wrong with that?
Justice Basson, I think it would be wrong to say simply because it is a taxing power, it is a plenary power. And here the minority in New Africa might be helpful. In New Africa, the minority only had to decide whether it was a taxing power or a regulatory charge, and then deal with whether Section 77 prevented that. So it could be a taxing power, but which is given in by way of subordinate, by way of allowing a minister to add or increase, to increase or reduce a tax in a regulation. So that would still not be, unless the in making the regulation, sorry, let me go back. If the power that is given will lead to the alteration of a statutory provision, for instance, the rate of VAT fixed in Section 7.1, then it directly affects the legislature's original power of determining that rate in the legislation. It's changing what the legislature has determined, exercising its plenary power to determine the rate of tax. Then the exercise of the power by the minister to change that would be the exercise of a plenary power. But it can be a plenary power without it being a taxing power, if I can put it like that. So it doesn't follow that simply because it's a taxing power, it is a plenary power. But if it is a taxing power, our primary submission is it cannot be delegated to a minister to exercise at all.
Yes, Mr. Manechi, just regarding considerations of fiscal policy, it appears that, and this is also in relation to the power of the minister to deal with interim matters and emergency funding that might be required. Short-term and discretionary macroeconomic stabilization is ordinarily the role of monetary policy, not fiscal policy. That's, well, that I might be wrong, but that's my understanding.
Yes.
And if we look at the Constitution, it looks like the Constitution was deliberately was drafted in a manner to deliberately insulate the function.
Yes.
This function of monetary policy aimed at economic stabilization from the political sphere.
Yes, I would accept that proposition. Just checking, I had a response from my left. I just want to check that that is my understanding. Yes, we would accept that, Justice Teron.
Suggesting that it is so. I'm asking a question.
No, we would agree with that, the question, this suggestion in the question, if I can put it like that.
Yes, but I think the respondents may have more to say on that.
Yes.
Because I think they suggest that the minister needs the power to adjust the tax rate swiftly and to respond to fiscal conditions. But thank you, Mr. Manechi.
Thank you, Justice Teron.
Adjournment for 15 minutes.
Thank you, Justice, Chief Justice.
Hano, onule hafu. Isarol, isarol. Onule hafu. Lili, sar no cheche hafu. Ho sala one. Hello everyone. Please let's get ready. And please, no food are allowed inside the court. Thank you.
Please rise for the Constitutional Court.
Mr. Manenche, just one short question. It seems to me that looking at the cases that you've referred to that have been debated in court, this court's answer to the question whether the Parliament still retains control in matters such as this is that there can be the control of Parliament that's required under the section 43, 77 and 43, that intersection, is not absolute control. Would you say in this case then that Parliament still retains effective control? And how?
Yes, Justice Dambuza, there is limited control by Parliament in that it controls whether the increase by the minister will stay permanent. And that control happens ex post facto in relation to the increase. The initial increase takes effect immediately and applies for 12 months, irrespective of what Parliament does. So, and the VAT that's collected is not reversible. It's not refundable to the consumers. To that extent, the ex post facto control and the deliberation that takes place after the minister's implementation, we would submit, is not effective. Is not what is required in relation to the exercise of a taxing power. It must follow upon due deliberation by Parliament.
So there's the required oversight function is not there.
We identify only one oversight, which is that the increase or reduction, the alteration of the rate, applies for 12 months. The only intervention by Parliament affects whether it continues to apply beyond the 12 months. That's the first thing. It sets no limits as to by how much the minister may decrease or increase the VAT. That's entirely left to the minister. There are no trigger indications in the legislation itself to regulate the minister. There is no insistence of Parliament's disapproval or approval before the VAT takes effect, the increase or reduction. All of that happens on the day the minister indicates.
I guess what I'm trying to find out is whether it's real control or it's not real control, or the question cannot be answered in that manner.
We would submit that it is not effective control. Effective control should affect whether the increase would take effect for the full 12 months and the extent of the increase. That would be effective control, constraining the minister's exercise of that power that is given to the minister. At present, it simply depends on the minister entirely. And the only controls one, other than whether the rate remains permanent, that's the control Parliament has. The other control is that the minister must act rationally, but that also just means you can challenge it later, but it will not affect, the tax will have been levied and collected. they suggest that there is political control, if I can put it like that, or the accountability measures in the Constitution, that a minister, in this case, for instance, who proposed a VAT increase and was going to go ahead if there was no court order, irrespective of the fact that there was a sizable number of political parties opposed to the VAT increase in Parliament, maybe even a majority opposing the VAT increase. They say a minister who goes ahead, given a majority opposing the VAT increase, would risk their own continuation as a minister, and that it is a check on its own because of the accountability checks in the Constitution. But to that we say it's a political risk. It's not a legal risk. Nobody can come to court to compel the minister to withdraw the announcement merely because it is not supported by the majority. If it was done following the proper procedures, and one can't say it was irrational, the mere fact that it's opposed by the majority is neither here nor there. When Parliament passes legislation subsequently withdrawing the increase, it would have taken effect. And politicians take political risks all the time. There are many votes of no confidence, matters of public record, which have failed, not because the complaint has no substance, but because it's a power play. It depends on how the power dynamics are in Parliament, whether those accountability mechanisms function or not. So those are not, our learned friends, well, let me say their clients have listed a whole host of measures which they say the court must take into account. Most of them are not legally effective. They're simply, the High Court said, you're asking us to rely on the benevolence of the minister. I would say the political consciousness of the minister. But that is not something we as citizens can take our hopes on.
Thanks. I guess you're not going to make it easy for me, eh?
Thanks, Justice Dambuza.
Thank you, CJ.
As a court pleases, we've asked for a relief.
You have.
Thank you, Chief Justice. We intend to address the following issues in the following sequence. First, we address the broader context of the VAT Act, and in particular, the interrelationship between Section 7.1 and Section 7.4 of the Act. Second, we deal with the defining features of Section 7.4 that we say render it constitutional on any of the routes relied upon by the DA. Third, we address the role of Parliament in the process, and responding to the issues raised by Justice Dambuza, address the question of parliamentary oversight in the process. Fourth, we deal with the three challenges described by my learned friend as three routes in the DA's heads. We deal firstly with the pleaded challenges, which is the imposition challenge, and secondly, the plenary powers challenge. Lastly, in time permitting, Chief Justice, we will then deal with the unpleaded New Africa challenge and make submissions on why the High Court was wrong when it found that the respondent suffered no prejudice in the court entertaining the unpleaded challenge, even though it wasn't raised at all by the DA in its papers. And then lastly, we'll make a submission or two on the question of relief. If I can then begin with the first topic, and that's to look at the broader context of the VAT Act, and particularly the interrelationship between Section 7.1 and 7.4. We submit, Chief Justice, that the starting point is what this court has repeatedly held, and that is that Parliament has an inherent power to tax. That power is a broad power, and there are no constraints in the Constitution as to how Parliament designs its tax structure. It is in this context that one must view the VAT Act, and specifically Section 7.1 and 7.4 of the VAT Act, bearing in mind the pleaded reason for the specific design chosen by Parliament, which is to enable a short-term solution to accommodate the fact that the legislative process is lengthy and therefore ill-suited to this particular form of tax. As this court recognized in New Africa, it is not practicable to adjust VAT rates retroactively, and so there is no prospect for retroactive national legislation. Also, the Minister tells us that this undermines good governance and sound fiscal management, because the adjustment of the VAT rate has to be factored into the budgeting process. Thus, at the point of finalizing the budget, you need a measure of certainty in order to properly comply with the rigorous constitutional and legislative prescripts that govern the budgeting process. It is against this backdrop that one must view the legislative scheme, taxing scheme, selected by Parliament for the imposition and alteration of VAT. And that scheme, for present purposes, comprises of Section 7.1 and Section 7.4. The wording of Section 7.1 is very significant. It says, and this is the introductory line to Section 7.1, subject to the exemptions, exceptions, deductions, and adjustments provided for in this Act, there shall be levied and paid for the benefit of the National Revenue Fund a tax to be known as the value-added tax. So it's built into the design selected by Parliament that the tax would be subject to adjustments provided for in the Act. Now then, Sections A to E of Section 7.1 sets out what goods and services VAT is to be levied on, and the remainder of Section 7.1 sets out the rate at which VAT is charged. All the parties accept that the provision of the VAT Act which imposes VAT is Section 7.1. The court will see that from paragraph 17 of the DA's heads. But in that paragraph, what the DA does not highlight is that in imposing that tax, Section 7.1 expressly provided for the tax to be subject to exemptions, exceptions, deductions, and adjustments. Now, the adjustment contemplated in Section 7.1 is then reflected in Section 7.4. It provides for a very constrained adjustment, and says if the minister, emphasis on the minister, makes an announcement in the national annual budget, it has to be done in a very specific way at a very specific time, contemplated in Section 27.1 of the PFMA, that the VAT rate specified in this section is to be altered. That alteration will be effective from a date determined by the minister in that announcement and continues to apply for a limited period of 12 months, subject to Parliament passing legislation giving effect to that announcement. So that's how the two sections work together. Section 7.1 expressly contemplates alteration or adjustment under the Act. Section 7.4 gives effect to that by allowing the minister a limited power to introduce such an adjustment. That then brings me to the defining features of Section 7.4. And in addressing the central question which this court faced, which we submit properly articulated, the central question is whether the scheme created by Parliament in the exercise of its power to tax is constitutionally permissible. And that scheme is Section 7.1 and 7.4 working together. And in answering that question, we say that there are 5 features of Section 7.4 which is worth highlighting. The first is that the power may only be exercised by the Minister of Finance. Now, I don't need to address the court on the significance of that part of Section 7.4. The Minister carries with him expertise and the expert support of National Treasury in exercising that power. National Treasury oversees fiscal policy, public finances, intergovernmental financial relations, expenditure planning, and the national budget. That's the first feature. It's the actor. The second is that the announcement must be made in the national annual budget. Now that carries with it 2 significant features. The first is a temporal one. So it can only happen once a year when the annual budget is tabled before Parliament. But secondly, it drags with it the entire process, the complex process which regulates budgeting, particularly national budgeting in the country. And I'll be addressing the court on that shortly. Thirdly, the section provides that the announcement is a temporary alteration in the VAT Act. In the VAT rate, it's not the imposition of a new VAT rate. It only applies for a maximum of 12 months unless Parliament passes legislation to give effect to it. The emphasis here is on alteration. Now, my learned friend Mr. Maneche has addressed the court on the basis that this alteration would always be an increase in the VAT rate and therefore onerous to poor people of this country. We don't dispute that an increase in the VAT rate will be onerous. But this court has to approach the question on an objective basis, bearing in mind that the adjustment could either be an increase or a decrease in the VAT rate. And if it was to be a decrease, the net effect of that would be to benefit the poor of the country for the 12 months that the minister's announcement is in effect. Fourth, the fourth feature is the specific nature of the tax at issue. VAT has very specific features. It's a consumption-based tax. It's levied on the supply or import of goods or services. Revenue is collected transaction by transaction, and if the tax is not levied at the point of supply, it is lost permanently. Unlike income tax, VAT cannot be backdated or retrospectively recovered through assessments. And if additional revenue is required urgently, the adjustment must occur prospectively and in real time. It cannot be made retrospectively. Now, these 5 features of Section 7.4 we submit must be considered with the 3 key purposes that's been identified in the pleadings before you. The first purpose behind Section 7.4 is to foster sound fiscal administration. It allows for short-term adjustments to the VAT rate to be announced in tandem with the national budget, ensuring coherence between revenue planning and expenditure priorities. The second purpose is it enables responsive fiscal management without displacing Parliament's ultimate legislative taxing authority. Without such a mechanism, the minister would be left without an effective tool to manage immediate revenue shortfalls or fiscal pressures. Money bills take many months, and that's the evidence before this court, even up to a year to pass. Meanwhile, government may face revenue shortfalls, be unable to meet spending commitments, or be forced to borrow money under pressure. Section 7.4 avoids that risk. It acts as a necessary bridge in a modern economy. The provision allows government to respond immediately while preserving Parliament's power to confirm, amend, or reject the adjustment in due course. And thirdly, it enables the minister to manage the danger of prematurely announcing potential changes to the VAT rate. And this links to the peculiar nature of VAT. Forewarning of a tax could likely affect or influence consumer behavior and the markets, and may therefore jeopardize projected revenues. So in summary, the provision enables the minister to act within a defined and tightly regulated window under direct parliamentary oversight, which I'll take the court through now, and within the framework of public finance legislation, with the rate adjustment lapsing after 12 months unless Parliament acts or enacts legislation to give it permanent effect. I then turn to the role of Parliament, the question of parliamentary oversight. We say that, in summary, Parliament has 3 key roles in the process. The first role was devising the scheme which I've addressed the court on, the Section 7174 scheme. It devised the scheme of imposition and alteration, and these 2 sections working together to achieve the governmental objectives already addressed. Secondly, by inserting the requirement that the Section 7.4 announcement be made in the annual national budget, Parliament exercises tight control over the process. And I'll take the court very quickly to what this entails. The starting point, of course, is Section 215 of the Constitution. That section, Section 215.1, says that the national, provincial, and municipal budgets and budgetary processes must promote transparency, accountability, and the effective financial management of the economy, debt, and the public sector. National legislation must prescribe, and that's section 2152, which says exactly what must be addressed in national legislation. But critically is 2153, which says budgets in each sphere of government must contain estimates of revenue and expenditure, differentiating between capital and current expenditure, proposals for financing any anticipated deficit for the period to which they apply, and an indication of intentions regarding borrowing and other forms of public liability that will increase public debt during the ensuing year. So this is the constitutional framework in terms of which the minister acts when he tables the budget in Parliament. Once a budget is tabled in Parliament, and we know that that happens in terms of section 27(1) of the PFMA. Perhaps I can take the court to section 27(1) very briefly. It deals with national annual budgets. 27(1) says the minister must table the annual budget for a financial year in the National Assembly before the start of that financial year, or in exceptional circumstances as soon as possible. It then says in 27(3), an annual budget must be in accordance with the format may be prescribed and must at least contain estimates of all revenue expected to be raised, and you will understand that VAT has a direct link to estimates of revenue raised, estimates of current expenditure, estimates of interest, estimates of capital expenditure, and estimates of revenue excluded in terms of 13(1) or 13(2). And it goes on. It has other particular requirements that a budget has to address. Once tabled, the Money Bills Act comes into play. And Section 7(2) of the Money Bills Act provides, so Section 7 deals with the introduction of the National Annual Budget. I'm looking at the Money Bills Act now, the Division of Revenue Bill and the Appropriation Bill. So we know that when a budget gets tabled in Parliament, it gets accompanied by the Appropriations Bill and the Division of Revenue Bill. These two bills, which ultimately, if adopted by Parliament, becomes acts, they give effect to what is contained in the budget. So the budget is meaningless unless it's given effect to, and it's given effect to through the enactment of DORA and the Appropriations Act. So Section 7(1), which deals with the tabling of the budget, Section 7(2) says that the budget has to be accompanied by certain documentation. The key one there for present purposes is 7(2)(a), the proposed fiscal framework. So it's a legislative requirement that your fiscal framework has to accompany your budget when it gets tabled in Parliament. Now, if one looks at the definition in the Monies Bill of a fiscal framework, it says that the fiscal framework means the framework covering the period of the MTEF that gives effect to the National Executive's policy, macroeconomic policy, and includes, this is going to sound familiar to the court, estimates of all revenue proposals, budgetary and extra budgetary specified separately, estimates of all expenditure, estimates of borrowing, estimates of interest. It's exactly the same issues which have to be dealt with in the budget, but just for a broader period. So your fiscal framework will be for a 3-year period, including the period of the budget and the next 2 years. That's your MTF period. Going back to Section 8 then, which talks about the adoption of the fiscal framework. Section 8(1) says that the National Assembly and the NCOP must refer the fiscal framework to their respective committees of finance. So the Standing Committee of Finance and the Select Committee of Finance received the fiscal framework. They have to hold joint public hearings on the fiscal framework. And they ultimately have to prepare a report for their respective houses. This report can do one of two things. It can adopt the fiscal framework, or it can amend the fiscal framework. So whatever is provided for in the fiscal framework, including we would submit an alteration to the VAT rate, has to be either adopted by the select or standing committees, or it can be amended by them. The Act allows the standing committee to directly recommend or report on an amendment of the fiscal framework. And that the court will see from Section 8(4). The report must include a clear statement accepting or amending the fiscal framework. Section 8.5, when amending the fiscal framework, a money bill, or taking any decision in terms of this Act, Parliament and its committees must. The Act then sets out a procedure that the committees must follow before they amend the fiscal framework. The Act also, in Section 8, subsection 6, allows the minister an opportunity to respond to this decision to amend the fiscal framework. The minister is given 2 days to address the select committee or the standing committee on its decision to amend the fiscal framework and to respond to the basis on which it amended the fiscal framework. So that's, Justice Dambuza, in answer to the question, that's the direct role played by Parliament in the adoption or amending of the fiscal framework. And I've demonstrated to the court the overlap between the annual budget, which is tabled by the minister, and the fiscal framework. Parliament's role becomes more acute because it then gets to either adopt or amend the Division of Revenue Bill, which is before it. And that's its first task, once the fiscal framework is adopted. It has to then consider the Division of Revenue Bill. The legislation provides that the Division of Revenue Bill can never be inconsistent with the adopted fiscal framework. And so immediately you see Parliament's role. Once it adopts the fiscal framework, the Division of Revenue Bill can never be inconsistent with the fiscal framework. Similarly, once Parliament is done with the Division of Revenue Bill, it turns to the Appropriations Bill. And the legislation provides that the Appropriations Bill that is ultimately adopted can never be inconsistent with the Division of Revenue Bill, or by then an Act, and the fiscal framework. So these mechanics which actually give effect to the budget are all based on the fiscal framework, which is ultimately the one adopted by Parliament. Now, if I can very quickly deal with the submission made by my learned friend, and which the court will find in the decision of the High Court, that what this will depend on. So we know the minister tables a budget. The budget is now inconsistent with the fiscal framework because Parliament, we assume, has now changed the fiscal framework to remove elements of it that it wasn't happy with. And the High Court found that the minister's decision whether or not to withdraw his budget and table a new budget, which is consistent with the fiscal framework, is a matter of what was described by the High Court as ministerial benevolence. So in other words, there's no legal compulsion on the minister to withdraw his budget and to introduce a new budget, and it's left to his benevolence. We submit that that's not an accurate reading of the framework. I've taken the court to what the Constitution requires a budget to address. Now, if the adopted fiscal framework is going to have a fundamental impact, for example, on the estimated revenues, then the minister cannot have a budget before Parliament which speaks to different estimated revenues from what is actually adopted by Parliament and reflected in the fiscal framework. That would be entirely irrational and unconstitutional. The Constitution has specific requirements for the budget, and we would submit that that would be acting inconsistent with those requirements. And therefore, the minister would be required to do what he did in this case, which is to withdraw his budget, to rework the fiscal framework and the basis on which forms the basis of his budget, and to place a new budget before Parliament, which then removes or is consistent with what Parliament has ultimately adopted in its fiscal framework. That's how the whole scheme works together. So that's the second, we would submit, very potent involvement and power of Parliament in the entire process. It happens through inclusion of those few words in Section 7.4, which is that the announcement can only be made in the national budget tabled before Parliament. The third way in which Parliament exercises control is what this court has already dealt with in the course of the morning. It's in the fact that it can ensure that the adjustment lapses without confirming it after 12 months. Now, against that backdrop, I can turn very briefly to the DA's challenges, Chief Justice. And the first is the imposition challenge, and you've heard my learned friend confirm this morning that their case is an absolutist case. They contend that Section 7.4 confers on the minister the power to impose a tax, and they say that this falls foul of the general principle that taxation is a primary legislative power and therefore unlawful. And we've already made the point in the heads, and my learned friend has accepted, that if one looks at the 4 cases relied upon by my learned friend, Fetcher, Shuttleworth, Casino Association, and New Africa, and not to forget Moslaba, none of those cases deals with a situation which I've described, the Section 7.1 and 7.4 interaction, an imposition by the legislature and the power, limited power to alter the rate for a limited period. All of the cases relied on deal with the imposition of a new tax. And despite this, the DA has stuck to its absolutist position, notwithstanding the clear authority of New Africa. And perhaps it's a good time to address what we understand New Africa to say. And building on the blocks that New Africa considered Executive Council, it considered Smith, and it departs from the principle that the separation of powers principle is never cast in stone, and that there's never complete separation of powers, and that there is always a partial separation of powers. And the question that arises in any given scenario is, where is that line drawn in this case? Which is why it calls for a contextual approach. Entirely consistent with Executive Council and our submission, because the court will see that President Chaskelson, as he then was, raised the question of a delegation, an unfettered delegation, being unconstitutional, which raises the question of, if there was a fettering to the discretion, would it then have been constitutional, irrespective of the power given? In other words, was it a power to amend a portion of the Act or a regulatory power? Now, the DA has raised in its heads 3 arguments, which I'll very briefly deal with. The first is that they say that the constitutional prohibition is not limited to the power to impose a tax, but also includes the power of taxation. Now, we say that the distinction drawn is with respect of a flawed one. We looked at the judgments of this court in Moslaba and in Shuttleworth, and it's very clear that where the court discusses the power of taxation of Parliament, that it's synonymous with the imposition of a tax. It's one concept. And we therefore say that the interpretation that the respondents have given to those words, the power to impose a tax, is consistent with interpreting a taxing power under the Constitution. It's the same thing. And we've given the court even though there are no South African cases on this question, Chief Justice, we've given the court the Canadian authority, which use the words, for example, where a tax is imposed by a functionary on its own accord. In other words, coming from the functionary, it itself imposes the tax. There are other Canadian cases that use the term ab initio, where tax is imposed ab initio. A similar concept, that it is the actual act of imposition which falls within the exclusive realm of the legislature, and not, for example, an adjustment to the rate of the tax. That brings me to the DA's second point, and I'm going to rush through this now. It says that the setting of the tax rate is a core part of the taxing power. Now, we disagree with that proposition. We rely on our disagreement with that proposition on two things, and the first is, very briefly, the New Africa minority judgment, where Justice Rogers sets out examples of legislation where functionaries have been, particularly the minister, has been allowed to change the rate of a tax. We also point to SARS's Annexure A to the heads, which the court will find at 006.2-53, where they provide a more expansive list of provisions in which the legislature permits the minister to adjust tax and custom rates. And the Income Tax Act is the one example that my learned friend struggled to distinguish. It's exactly the same like the situation with the VAT rate. The third thing, very briefly, that the DA says is that the argument is precluded by Casino Association. And they say that in Casino Association, what you dealt with there is that the Northwest Gambling Act created a gambling levy, but left it to the minister to set the rate. We say with respect, that's not a correct reading of the Act. If the court has regard to the Gambling Act dealt with in Casino Association, you will see that at Section 87(1) permitted the MEC to determine two things: the basis on which the gambling levy was payable, as well as the rate of the gambling levy. So it wasn't only confined to determining the rate, it was also the basis on which the levy was payable. In any event, and in the VAT Act, what you see is that Section 7(1) creates every element of the VAT liability or the VAT tax, but allows the minister just to make a temporary adjustment to the rate for a limited period. The second basis on which Casino Association is distinguishable is that the adjustment in the VAT scenario falls away if not confirmed by Parliament, whereas the Northwest Gambling Act does not contain a similar provision. So once the MEC invokes the right under Section 87(1), it's a permanent alteration of the rate of the gambling levy. Thus, the minister does not impose a tax. The DA simply failed to plead or make out a case which engages with the true nature of Section 7(4), namely that to ensure sound fiscal management, Parliament has delegated the power to temporarily alter the VAT rate to the minister. There is no argument by the DA that engages the nuance, or this nuance, and none of the case law relied upon addresses this point. On the contrary, the foreign case law, which we won't address you on, Chief Justice, we leave that to my learned friend, Mr. Marcus, to do. The foreign case law demonstrates that this is a permissible and necessary power for the minister to have. The plenary power challenge, you've heard my learned friend, it's also based on an absolutist stance that the assignment of plenary power, that Parliament may never delegate its plenary legislative authority. We have addressed the court on our interpretation on New Africa. We understand New Africa to, as a matter of principle, say that irrespective of whether the power concerned is a plenary power or a regulatory one, that the court approaches the permissibility of the delegation on a contextual basis, having regard to all the relevant features of the delegation. And so for that reason, we say that the plenary power challenge falls foul of New Africa and should be dismissed.
The High Court accepted all these good reasons you advance for the need and convenience of the mechanism in Section 7(4), but it was not convinced that this is the only way to achieve the much-touted fiscal agility. And it even gave a practical example that Parliament could, for example, require that any VAT increase be approved by a parliamentary resolution within a short period, as is done elsewhere. Why is that not a viable alternative?
Chief Justice, I think the starting point is to approach the matter on the basis that the Constitution deliberately allocates the power to design the tax system to Parliament, and does so for good reason. And with that allocation does come a measure of difference in terms of how Parliament ultimately designs it. And so that's the first answer to the issue raised by the High Court. The second thing is the High Court found the provision wanting based on the lack, what they describe as the inadequate parliamentary oversight. The High Court found that the influence on the minister's tabling of the budget was a matter for ministerial benevolence and not, as we've argued today, a requirement that flows from the Constitution. So we would submit that had the High Court approached the matter on the basis that we've argued today, that the High Court would have reached a different conclusion. We also, and I have to raise this, the basis on which the High Court ultimately made its decision was on the New Africa contextual factors. That we submit was never properly before the court. And we've in our heads of argument, taken the court step by step to how the litigation unfolded, to the allegations made by the DA, the way in which it cast its case in the urgent, the response by the Minister of Finance, which is to say, look, this absolute proposition no longer applies because of New Africa, but we note that New Africa is not your pleaded case. The DA then comes back in reply and says that the minister mischaracterizes its case, that it doesn't rely on New Africa, but it relies on the two absolutist propositions, which we submit then shaped how the matter unfolded after that. The minister says expressly in his affidavit that he is addressing some of the New Africa factors out of caution, but that he's not doing it in any detail because it hasn't been pleaded by the DA. And that's the clearest indication that there's an insufficiency in the pleading and an insufficiency in the response. It's not the response the minister wanted to give, but because it hadn't been properly pleaded, the minister didn't go the one step further of addressing or assuming an aspect of the case which simply wasn't there. So we'd submit that the basis on which the High Court reached the decision, which was on the New Africa contextual factors, it wasn't open to the High Court to do that. And we've given the references in our heads of argument of how that story that I've just described, how it unfolded. And therefore we agree with the High Court, we disagree with the High Court's finding that there was a lack of prejudice and that it was able to decide the matter based on the factual material on the papers. The factual material was skewed by the pleading. And to that extent, there was prejudice. And that prejudice is foreshadowed in the minister's answer when he says, I'm not going to go into detail because it's not part of the pleaded case.
Okay.
Thanks, Ms. Pillay. Just one issue from my side. Do you seek to rely on New Africa in the proposition that the delegation of plenary power is not absolute? And once we get over that hurdle, there's a number of factors to look at. Is that correct?
That's correct.
The first factor in New Africa is the extent to which the discretion of the delegated authority, that would be the discretion of the minister, is structured and guided by the Enabling Act. Can you point to anything in the Enabling Act that structures and guides the exercise of that discretion?
Justice Colopin, the primary feature which we would point to is what I've addressed the court on. It's the inclusion of the words that it has to be tabled in the annual budget, because those words cannot be seen in isolation. They drag with them the entire substrata of legislative provisions which govern the way in which the annual budget is prepared and is ultimately placed before Parliament. So what you don't have is a minister waking up one morning and saying, I'm going to increase VAT by 5%. That's simply never going to happen. The minister, in preparing his budget, is obliged to follow the PFMA, is obliged to follow the Money Bills Act and the Constitution. And that we submit is a significant fettering of the minister's ultimate discretion on the question of either increase or decrease.
Okay. If I suggested to you that the reference to those exemptions, etc., are quite wide in general, and do no more than require the minister to take into account those. And the minister could quite easily say, well, I've considered all of that. I've acted in accordance with the Act, but I'm going to increase that by 5%. It would be very difficult to suggest that the minister has acted outside of the structure and guidance given by the Act. But put more clearly, other jurisdictions have dealt with that particular provision perhaps in a more focused way, by providing some parameters within which the minister may act and beyond which he may not act. Would the absence of those suggest that one may lean towards the conclusion that there is no real structure and guidance in real terms? Because ultimately it touches on the next issue, the importance of the measure. And if there's no structure and guidance, then the importance takes on a greater significance, because its impact, just not on the fiscus, but its impact on consumers may be quite devastating. And in all of this, there's nothing that the Act provides to guide, to constrain, and to limit the minister. And those become important simply because one is dealing with a delegation. And therefore, yeah.
Justice Colopin, we would submit that the structure and the guidance that you refer to comes in by virtue of the tabling in the national budget. Now, I've referred the court to the PFMA, to the Money Bills Act, to the Constitution. The tabling of the national budget is not a neutral event. It's a highly circumscribed, regulated event. It drags with it a myriad of other legislative provisions which governs what can be in the budget and how it gets presented. Following from that is once the budget is tabled, there are further, we would submit constraints that then come into play. That would be the adoption of the fiscal policy, the fiscal framework, the adoption of DORA, the adoption of the appropriations bill, which ultimately give effect to the budget. So our short answer is, just by virtue of the introduction of that language, that it has to be in the annual budget, because the budget is highly legislated and circumscribed, that it drags with it all of those provisions in how the minister exercises his power.
Then finally, just arising from that, if that is indeed so, the tabling of the national budget and its ultimate approval, or failure to be approved by the National Assembly, has no impact on the minister's announcement of the coming into operation of any VAT increase that is announced in the budget. It's almost insulated and protected, not so, from any parliamentary process, at least for 12 months.
We would submit not, Justice Colopin, and we submit, and that's what we've addressed earlier. Where it comes in to the process is the following. When the minister tables his budget with his announcement, all right, that announcement is also featured in the fiscal framework. The fiscal framework gets dealt with by the different committees of Parliament, has to be either adopted or amended. Now let's assume that houses of Parliament are unhappy with the VAT increase, which is featured in the fiscal framework. And they can either adopt it, accept it, or they can amend, and assuming they amend to remove it. The implication of that is that the Division of Revenue Act cannot feature the VAT increase, and neither can the Appropriations Act. It also means that the budget that the minister tabled is not a fair reflection of projected or estimated revenues, because there's been now a change in circumstance, which is the different stance taken by the committees of Parliament. And we would submit it is therefore then legally incumbent on the minister to, in order to comply with Section 215 of the Constitution, to then withdraw his budget and to place a new budget before Parliament, which would then take into account the changes in the fiscal framework, which would influence the DORA and the Appropriations Act. So we would submit there is an indirect way in which the steps taken by Parliament post the tabling of the budget does impact the so-called announcement in the national budget. The announcement is nothing more than a reflection in the national budget of an increase in the VAT Act. Sorry, in the VAT rate. That's what the so-called announcement is.
But if you say that there's an obligation on the minister to, in a sense, reverse that, how does that square up with the language of 7.4, which expressly says that the rate specified in this section is to be altered if he makes an announcement? So the announcement has the effect of resulting in an alteration of the rate, and that will be effective from a date determined by the minister for a period of 12 months.
Now, we would submit that there is a change in circumstance, which is that the contents of the budget has not been accepted by Parliament, and Parliament has in fact gone one step more further, and they've amended the fiscal framework, that it would be incumbent on the minister to retable to withdraw the previous budget, because it has now been rendered superfluous by the conduct of Parliament, and to retable a budget, which is exactly what happened this year.
Say that at best is a grey area, because the minister could say, well, 7.4 kicks in, and even if I withdraw or retable, I'm retaining the VAT increase, because I rely on 7.4, and you, Parliament, are bound to accept the determination I've made, at least for a minimum period of 12 months. And as I understand it, notwithstanding the indignation of Parliament, it may not do so before 12 months either, not so?
Yes, that's correct.
12 months is the maximum and the minimum period.
Yes, but Justice Collison, the minister would not be able to run a budget that's inconsistent with what has been adopted by Parliament and with the two acts that give effect to what is contained in the budget. And we would submit that the minister would be in a position where
There'd be a financial crisis, you'd say.
he simply can't run with a budget
Okay.
that's inconsistent with the fiscal framework.
So then good sense would have to prevail.
We submit so.
But the law might stand in the way of good sense.
We submit that it shouldn't. There's a change in circumstance. It would entitle him to withdraw his budget and to place a new budget, which is consistent with what Parliament decided.
Thank you, Ms. Blay.
Ms. Blake, there is much said about the absence of provision for any form of public participation in the process. What do you say about that?
Justice Dembuza, once again, the public participation features in the process through the requirement that it form part of the budgeting, the tabling of the budget in Parliament. So, of course, before the minister exercises the announcement, the right to announce in his budget, there is no requirement that he himself has to give Audi to anyone. But the way in which the budgeting system is structured, there's a pre-budgeting situation where there are public hearings around the proposed budget and departments have an opportunity to be heard on the proposed budget. The actual budgeting process itself is designed in such a way that the fiscal framework has to go to the select committee and the standing committee, and when it does, both committees have to hold joint hearings on the contents of the fiscal framework, which is really the substrata of the budget.
Okay, where is the public participation process provided for exactly?
It's in Section 8 of the Money Bills Act.
Thank you. Thank you, Chief Justice.
Yes, Ms. Pillay, let me raise with you my concern. Maybe you could allay my fears. This is in line with the question that I put to Mr. Mainage on the text, context, and purpose, that you have to read Section 7.4 in conjunction with Section 7.1. If 7.4 on your construction does not amount to the imposition of tax, but Section 7.1, the title of it, the heading says, or reads imposition of tax, how do you then reconcile the two?
Justice Matopo, sorry, I just want to look at the heading. Section 7 as a whole, the heading is the imposition of tax, and that's exactly what's reflected in Section 7.1. That's the section which imposes the tax, but makes it subject to exemptions, alterations, adjustments. And Section 7.4 comes in as the alteration. So we would submit that when one reads Section 7.4, you can't read it in isolation. You read it with Section 7.1, which is where the imposition takes place, and Section 7.4 comes in as the alteration.
But then if you read that also in conjunction or in line with Section 77, where is the link? Is there no disjuncture there?
We would submit not. Our submission is that when the minister exercises the power under Section 7.4, that Section 77 doesn't come into play at all, because Section 77 governs the conduct by Parliament in enacting legislation. So it applies to bills before Parliament, and therefore is not impacted by a decision taken by the minister under Section 7.4.
The applicant relied on cases from this court, Executive Council, Casino Mohlaba, New Africa, the ROOC, as authorities that buttresses its point. Would you say those cases are distinguishable?
We submit, Justice Matopa, that they are distinguishable. All of those cases dealt with an amendment to an act itself. Section 7.4 doesn't result in an amendment to Section 7.1. It works alongside Section 7.1 for the brief period for the 12 months. If nothing is done by Parliament to confirm the increase or decrease in Section 7.1, Section 7.4, Section 7.1 remains exactly the way it was.
So if if you are to be successful, the holding would be that there is no amendment to the Act, but it's an alteration,
yes,
or a reduction.
That is so, Justice Matopa.
But if the quantum thereof is amended, on the example that Mr. Maineji postulated of his village, where they would buy at a particular rate and they would not be able to get the refund, the irreversibility point that he raised. Isn't that a factor that ought to entail public participation?
Justice Matopa, we accept that if there is an increase, and bearing in mind that Section 7.4 contemplates an adjustment, it could be up or it could be down. We could be dealing with a situation where government decides to protect the economy from an economic shock, to drop that, in which event the public would benefit from lower VAT for the 12 months until Parliament decides whether or not to confirm. So that's the first thing. The Act contemplates an alteration. It could go up, it could go down. Secondly, we accept that if VAT is increased, that you cannot reclaim the VAT, people cannot reclaim the VAT that they've paid over a period of time.
You would recall that when the minister attempted to increase the VAT, there was a huge outcry. And this huge outcry necessitated this litigation. And because the South African public, without speaking for them, would have said, this increase has not been discussed with us. It's just imposed. And then we ought to have, because we have our own representatives in Parliament, who should have taken up the cudgels for us to say, why the increase?
Now, Justice Matopa, that process that you describe is exactly what the Minister and SARS have identified as taking time. The Parliament, the ordinary parliamentary process where you have your public participation. It's a timely process. It would circumvent the very purpose of allowing this short-term intervention by the Minister. If you were to subject this process to the same public participation requirements as you would ordinary legislation. So the answer to the public out there is that when the Minister takes this decision, he takes this decision in the public interest because he is considering a variety of factors, including that there is a need from an economic perspective, a fiscal management perspective, there is a need for additional income to come in. In this case, what my learned friend did not emphasize is that when the VAT was dropped back to 15, social spending was cut in order to make up for the difference. Now that tells the court that there's always a variety of interests that have to be juggled. That's the very difficult and technical process that budgeting requires.
So if I were to understand your argument correctly, the minister is not advocating for a change of the VAT, and if that is the position, the power that is located in Section 77 does not get triggered in.
Yes.
I'm not sure whether it is the minister or SARS that seems to have embraced the minority view on the Section 77.
We do as well.
You do as well?
Yes.
But now, do you embrace it on the basis that it allows the minister, as he has done in the present proceedings, to act swiftly? And whatever he has done, it's not a money bill? Would that be a fair characterization of the ministers?
Yes, it is. As we understand Justice Rogers' minority judgment, it's the following, that from Section 73 onwards of the Constitution, Section 73 to Section 77, it would govern how any bill which is to be tabled before Parliament, the process for any bill to be tabled before Parliament, depending on the content of the bill, it will have a bespoke process. For example, a bill amending the Constitution would attract Section 74, a money bill would attract Section 77. So all bills have to follow some sort of process. And because you're dealing here not with a bill before Parliament, but with executive action, Section 77 doesn't get implicated at all. And if it were to get implicated, it would mean that in any environment, on any issue, the ministers or functionaries would not be able to act because the procedure prescribed in Section 77 to Section 73 to Section 77 have not been complied with.
So this amendment by the minister, the proposed amendment, do they raise revenue or they don't? But obviously they do, because there must have been a shortfall in the minister's budget.
Not the amendment, but the alteration.
I mean the alteration, okay,
Yes.
whatever we call it, let's
Yes,
put the
no,
proper
it's
label.
important that it's not an amendment, yes, it's an alteration.
The alteration.
The alteration may result in raising revenue. The alteration could also result in the opposite, in the sense that less revenue is raised. And this court has to
But in the
approach,
circumstance of this case,
in the circumstances of this case, you're dealing here with an increase.
It
But
was
the
an
court has to
increase.
approach the question of constitutionality having regard to both. A potential increase as well as a potential decrease, because the power is a neutral power. It could
but
go
the
up.
dominant purpose of the minister was to raise revenue by increase.
When you say the dominant purpose,
So let's say the purpose of the minister, let's forget about the label. The purpose of the minister with this adjustment or alteration was to raise revenue. Is that not correct?
Justice Matopo, on the question of the dominant purpose, I think I just have to take 2 steps back, because the jurisprudence from this court has not been consistent on the question of dominant purpose. Some judgments say that you consider the dominant purpose of the legislation. Some judgments say you consider the dominant purpose of the charge. Some judgments say you consider the dominant purpose of the decision. And the latest judgment on our count, which would be Casino Association, says you consider the dominant purpose of the charge, which is VAT. So just on the question of dominant purpose, it's not clear to us exactly.
Okay, maybe
what
let's row away from
Yes.
that dominant purpose because of the differences that you've alluded
Yes.
to. I have concerns. The other concern is the one that you raised with my sister Dambuza about the parliamentary or public participation in the joint standing committee. At what stage is this process being done? And then here we have a minister poised to make the announcement. When does the joint standing committee sit and who comprises it?
So the joint standing, the Select Committee of Finance and the Standing Committee of Finance receive the fiscal framework after the budget is tabled, and the budget would reflect the minister's announcement or alteration. But our submission is that that alteration reflected in the budget is of no moment, because ultimately the minister is bound to act in compliance with what Parliament ultimately designed. That's the way in which the legislation is structured. The legislation expressly provides that you can either adopt or amend the fiscal framework. The legislation expressly provides that DORA has to be consistent with the fiscal framework. It can't be at odds with the fiscal framework. The legislation expressly provides that the Appropriations Act has to be consistent with the framework. So through that, the minister cannot run a budget which is at odds with the fiscal framework and these pieces of legislation which give effect to the budget. That's how the budget finds expression, through the Division of Revenue Act and through the Appropriations Act, which is why the legislation requires that those acts accompany the budget when it's tabled in Parliament.
All right, just finally, on the pleaded or unpleaded case. The judgment of the High Court is replete with references to New Africa. And you'd say this was not alleged or pleaded.
We say that the contextual factors set out in New Africa were not expressly pleaded. In fact, we go so far as to say the DA expressly disavowed a reliance on New Africa, which is what they say. We've given the reference to that in our heads of argument.
But if, so are you saying to the extent that the High Court referred to New Africa in its judgment, it erred? Or it erred in respect of the content-specific?
Yes, the latter, Justice Matopo. It erred to the extent that it entertained a challenge based on the contextual factors. It didn't err to the extent that it found that the absolutist approach was inconsistent with New Africa. That was open for the High Court to find, and in fact it did find. On the contextual setting, that level of the challenge, we say, was not properly before the High Court, specifically because of the way in which the DA pleaded.
So can the judgment, if one were to, can the judgment be saved? In other words, on the absolutions, we say you were correct. On the content-specific, which was not pleaded, and then we would say the High Court was incorrect.
Yes.
And then when we take that into account, do we have a judgment of the High Court that is sustainable?
We would submit on the dismissal of the two absolutist points, you do. But you don't have a judgment that finds that Section 7.4 is unconstitutional, because that portion of the judgment wasn't properly before the High Court, we say, on the pleaded case.
So just repeat it again, because it's very important.
Yes, so our submission is it was open for the respondents to argue before the High Court that the two absolutist arguments put forward by the DA were not consistent with this court's jurisprudence, particularly New Africa. And so the court could validly, and we say legitimately, find that both causes of action that the DA relied on lacked merit and should be dismissed, right? Where we have a difficulty, Justice Matopo, is where the court stepped into the shoes of the litigant in a sense, and it devised a cause of action which was simply not pleaded. And that's the contextual factors, where it ultimately found that Section 7.4 is unconstitutional. That portion, we say this court should not uphold, because the High Court erred in entertaining a cause of action that was not raised by the DA and not properly pleaded.
Could it have been possible for the DA? No, thank you very much. Thanks.
Advocate, play this side. You, in your address, you mentioned that what the High Court failed to understand was the fact that it's not about ministerial benevolence, the change to the VAT rate. There is a statutory framework that governs that. You dealt with it in your address in uninterrupted time. I just want you to break it down for me so that I follow it. So yes. It starts with Section 7.1.
No, Justice Nuko, with respect, it starts at Section 215 of the Constitution.
Okay, let me give you my understanding.
Yes.
So as far as I understand, so that when I get lost, then you can take from there. And it starts from, I'll just start from the VAT Act. It's Section 7.1 that sets the tax rate subject to alterations, exemptions, and all of that. And then it goes to section 7.4, that would then deal with the alteration which may be done by the minister. And now I think your explanation, I want you to take me from there. You say that alteration can only happen during the announcement of the budget. And where do we find that?
So if you look, Justice Nuku, at how Section 7.4 is formulated, I'm going to, forgive me, I'm going to read Section 7.4 out. It says, if the minister makes an announcement in the national annual budget, contemplated in Section 27. Now,
so it's there in Section 7.4.
It's in Section 7.4.
All right.
Now, we would submit that once those words appear in the national annual budget contemplated in Section 27.1, a series of constitutional and legislative provisions are triggered.
That's what I
Yes.
would like you to take me through.
So it starts with Section 215 of the
Yes.
Constitution. And Section 215, particularly 215.3, tells the minister what his budget must contain. And that's the language used. It says budgets in each sphere of government must contain 3A, estimates of revenue and expenditure, differentiating between capital and current expenditure. So it's a constitutional requirement that your budget must reflect your estimates of revenue. Now, then the next legislation that kicks in after 215 is the PFMA, Section 27.1, which requires the minister to prepare a budget and then to table the budget. Perhaps let me go take you to 27.1 just to tell you the exact words used. 27.1 says the minister must table the annual budget for the financial year in the National Assembly. And then 27.3, this is key, Justice Nuku says, an annual budget must be in accordance with a format as may be prescribed and must at least contain, so it's a requirement, a statutory requirement, that the annual budget must contain estimates of all revenue expected to be raised during the financial year, estimates of current expenditure, estimates of interest and debt servicing charges, estimates of capital expenditure, etc. Right? Then if one goes to the Money Bills Act, that's the next piece of legislation. And if one looks at the definition of fiscal framework in the Money Bills Act, you'll see that the fiscal framework means the framework covering the period of the MTEF that gives effect to the National Executive's macroeconomic policy and includes estimates of all revenue proposals, budgetary and extra budgetary specified separately, estimated to be raised during that period. So it mimics what has to be dealt with in the budget. And then, Justice Nuku, the next thing to go to would be to Section 5 of the Money Bills Act, which prescribes an entire procedure that has to be gone through in the preparation of the annual budget. It says when you prepare your annual budget, this is what you have to do, and it sets in place very distinct steps that must be taken before the budget is prepared. Then you go to Section 7, which is the actual tabling of the budget. So Section 7.1 of the Money Bills Act says the minister must table the national budget, the national annual budget in the National Assembly, as set out in Section 27, and I've taken you to Section 27, at the same time as the Division of Revenue Bill and the Appropriations Bill. So that's legislatively provided for. Your annual budget must be accompanied by these two bills. It cannot leave one of the two behind. And then it says in 7.2, in addition to the information stipulated in Section 27 of the PFMA, the documentation tabled by the minister with the national annual budget must include, again, it's a peremptory, the proposed fiscal framework. So the fiscal framework has to be part of your budget. The key macroeconomic assumptions underlying the fiscal framework, key fiscal ratios for the next 3 financial years, including revenue, expenditure, the primary and overall balance, and outstanding general government and public sector debt at the end of the financial year, as a percentage of gross domestic product. Tax and other revenue proposals, including the contribution of the different revenue categories, etc. So our submission is that an increase, for example, in VAT forms a key part of the fiscal framework and the information to be dealt with in the budget. Then if you go to Section 8, that's the next legislative provision, which is the adoption of the fiscal framework. 8.1 says that the National Assembly and the NCOP must refer the fiscal framework to the respective committees on finance. 8.2 says that the two committees of finance, the select committee and the standing committee, must conduct joint public hearings on the fiscal framework.
Does it prescribe the time frame? Not.
Yes, it prescribes when they must revert, and that's 8.3. It says the committees must, within 16 days after tabling of the national budget, or as soon as possible thereafter, report to the National Assembly or the NCOP on the fiscal framework.
That's after having considered the
Yes, that's correct. They must report back to the NA and the NCOP.
And sorry to interrupt you. So the announcement relating to the alteration of the VAT rate will be part of that fiscal framework, which will be considered in the job.
It has to be part of it. That's what's required by the definition of fiscal framework. Then you look at 8.4. It says that the report must include a clear statement accepting or amending the fiscal framework. So the two committees either accept the proposed VAT increase, which is part of your fiscal framework, or they can amend it, they can remove it. It then says, when amending the fiscal framework, in other words, they remove the VAT increase, a money bill or taking any decision in terms of this act, Parliament and its committees must, and then it gives factors A to G. Ensure that there is appropriate balance between revenue, expenditure, and borrowing, ensure that debt levels and debt servicing charges are reasonable, ensure that the cost of recurring spending is not deferred to the future generations, ensure that there is adequate provision for spending, etc. So these are the kind of considerations the minister would make when he prepares your budget. That's what he's considering. So what the Act now requires is where the parliamentary committees amend the fiscal framework, that they have regard to similar considerations to make sure that they're ensuring sustainability, the balancing of revenue, expenditure, etc. Then if you look at...
Sorry to interrupt you. So can these committees, when considering the fiscal, framework, decide that they're going to reduce the VAT rate that is proposed by the minister, or they're going to not accept it at that stage?
Their power to amend is not constrained in the legislation. And so we would submit that power to amend includes the power to ignore or remove.
Because it's part of the items that would be included in the framework.
In the framework, that's correct. Yes.
All right.
Yeah. And then just to round off the argument, the answer to your question, Justice Nuku, if you look at 8 subsection 6, if the report includes amendments to the fiscal framework or revenue proposals, which is exactly what we're talking about, it says the amendments must comply with 11.3 of the Act, and then importantly 6B, the minister must be given at least 2 days to respond to the report and any proposed amendment prior to the submission of the respective reports to the Houses. So they give the minister an opportunity to respond to their decision to, for example, remove his increase. And then if you look at 9, any amendments to the Division of Revenue Bill, the Revenue Bills or the Appropriation Bill must be in accordance with the estimates of revenue and expenditure, excluding statutory expenditure, service debt, etc. So in other words, your Division of Revenue Bill, your Appropriations Bill have to be consistent with those revenue projections which underpin your fiscal framework. And in fact, sections 9 and 10, 9 relates to the Division of Revenue Bill, 10 relates to the Appropriations Bill. Both of them have got express provisions that the Division of Revenue Bill cannot be inconsistent with your adopted fiscal framework.
So it will start with the adoption of the fiscal framework.
Yes.
Then it will go to the Division of Revenue.
Yes. And
bill,
that's the sequence.
which must then be consistent with the adopted fiscal framework.
Yes, and then it's
And then the
appropriations.
appropriations bill.
And appropriations has to be consistent with both steps.
With both, okay.
Division of revenue and the fiscal framework. And so we would submit that's how Parliament exercises its control. And so ultimately, going back to section 2153, which requires that the minister tables a budget which sets out estimates of revenue. If those estimates are significantly changed by what comes out of the parliamentary process, then we would submit it's incumbent, in light of that change of circumstance, it's incumbent on the minister, in order to comply with 2153, to withdraw his budget and to table a new budget which takes into account the new revenue projections in light of what Parliament has decided. Otherwise, we would submit in contravention of 2153.
Thank you, Mr. Speaker.
Ms. Pillay, I want to understand the argument that the minister has the power to adjust the tax rate. And I'm asking that with respect to the principle of no taxation without representation. I'm struggling to understand how this is distinguishable from Shuttleworth, Mahlaba, excuse me, and Casino Association. In delegating the power to the minister to adjust the tax rate, and I use your language, is that not an imposition of national tax for the purposes of Section 77(1) of the Constitution?
Justice Saran, we would submit not. We would submit that when the Constitution uses the term imposition, so when the term imposition of taxes is used, or even a taxing power, which is what you would see, for example, in Mohlaba and other judgments, that refers to the imposition of a tax ab initio, or the creation of a new tax. So in other words, Parliament, it's only Parliament that has got the power to create a new tax. Where Parliament delegates to a minister the power to adjust the rate, we would submit that that power is not the power to impose a tax. Well, it's not a taxing power. It's a very constrained power, and it's a power to temporarily adjust the rate. And for the reasons set out in Justice Rogers' minority judgment, where he goes through all the legislation that permit the temporary adjusting of a rate, and Annexure A to SARS's heads of argument, as well as the foreign cases, we would submit that that is permissible as the exercise of a delegated power.
To the foreign cases, but still, since you mentioned them, the foreign jurisdictions that allow that have a different order to ours. Especially in the UK, they have parliamentary sovereignty. And doesn't that mean that we are not actually comparing apples with apples?
The foreign cases are relevant, Justice Duran, to the extent that they demonstrate, firstly, the need for such a power, and that such a power can exist in a constitutional dispensation. Which brings us back to properly interpreting the imposition of a tax in our dispensation. None of the cases which deal with the imposition of a tax have interpreted that to mean anything other than, in those cases, they were dealing with the imposition of a new tax. So we would submit the court is able to interpret that to mean that the imposition of a tax is the creation of a tax ab initio.
I'll come back to it, but I just don't want to leave Shuttleworth right now. Shuttleworth set out the dominant purpose test as to whether the primary or dominant purpose of a statute is to raise revenue or regulate conduct. In adjusting the VAT rate, is the minister regulating conduct or raising revenue?
So Shuttleworth looked at the dominant purpose of the legislation to decide whether or not it was dealing in that case. In trying to categorize that exit charge, was that exit charge regulatory in nature, or was it a tax? And that's how it looked at the dominant purpose of the legislation. We would submit in this scenario, if one looks at the dominant purpose of the VAT Act, it's clearly a tax. It's a taxing instrument. But what the court has to consider is the nature of the power given to the minister. And we say that the power given is not a taxing power, because we interpret a taxing power to be the imposition of a new tax.
In exercising the power, and I use your language, is the minister regulating conduct or raising revenue?
Justice Turan, we submit that when the court approaches that question, it must do it on the basis of how Section 7.4 is formulated. Section 7.4 permits the minister to make an alteration. The alteration can be up or the alteration can be down. So it's certainly not to raise taxes. I'm reluctant to argue that it's regulating conduct, but I can argue with confidence that it's not to add to the fiscus or to raise taxes.
Raising revenue.
Yes, to raise revenue.
It's very seldom that it adjusts downwards.
But with respect, we submit that when you approach the question of the constitutionality of the provision, it must be in how the provision is framed, and the provision permits both an increase and a decrease. And the question is that which contemplates either up or down, is that constitutional?
And there lies my concern, and now I've put the question to you, that in exercising that power and in adjusting upwards, is the minister not raising revenue? Because I'm not sure it can be said is or she will be regulating conduct.
We would submit that in increasing VAT, let's assume that that's what the minister does, in increasing VAT, what the minister is doing is the minister is adjusting the rate, but he's not creating or imposing a new tax. That's done through Section 7.1. And therefore we say it's not the exercise of taxing power, or it's not the imposition of a tax.
The respondents generally suggest that the powers that are given to the minister under Section 7.4 are concerned with practicality. You support that view?
We accept that, yes.
And this would be to allow the minister to adjust the tax rate swiftly and temporarily to respond to fiscal conditions. But isn't it so that short-term and discretionary macroeconomic stabilization is the role of monetary policy and not fiscal policy?
Justice Turan, we would submit that it certainly is part of fiscal policy. It's not constrained to monetary policy. It forms a central part of what the Minister of National Treasury and all the government departments do when they engage in this budgeting exercise, particularly given that our budgeting landscape is not only for 1 year, but also projects into the future. So certainly those issues get dealt with in the budgeting process.
Why would it not work to say to the minister, you can make the announcement in the budget speech, but that announcement will only take place after parliamentary approval?
For the reason, Justice Turan, that on the evidence before you... Sorry.
And there could be provisions for that to be done ordinarily, which may take 12 months, but there also could be provisions for it to be done in the short term if economic conditions dictate so.
Justice Turan, we would submit that on the information before this court, the pleading before this court, you can accept that the ordinary legislative provisions processes would take 12 months. On the hypothetical that you've posed, there's no indication of what that would look like in practical terms. What would a truncated system look like? How much of time would you give the public to respond? And is that doable on Parliament's current calendar? That evidence is simply not before you.
Because we don't know what it would look like, can't we say that attempt should be made to show us what it would look like?
With respect, we get back to what it is that the Constitution allows Parliament to do. And by giving Parliament exclusively the power to tax, In our submission, Justice Saran, that does carry with it a certain amount of deference to Parliament in terms of how it carries out its constitutional function. And so when Parliament devises this scheme, the 7174 scheme, we would submit that it does that knowing the practicalities involved and catering for those practicalities.
That's not the test we apply in this court. That's not the test we apply in this court when we look at legislation and the powers that have been given and whether it's constitutionally valid or not.
Justice Ron, as I understand it, there are instances where this court will defer if the circumstances warrant deference. And we would submit that the exercise of an exclusive taxing power is such, not completely defer in the sense that it insulates Parliament's conduct from inquiry, but certainly Parliament's choice of design is something this court would defer to unless it can be shown that that choice of design is unconstitutional.
At the end of the day, that is the test, to look and to see whether what Parliament has done is constitutional or
Yes.
not. Yes. Thank you, Ms. Pillay. Thank you, Chief Justice.
Very much, Ms. Pillay.
Thank you,
We'll take the lunch adjournment until 2 p.m. Corrections.
for the Constitutional Court.
You may proceed, Mr. Trengrove.
May it please you, Chief Justice, members of the court. I will address firstly the New Africa test and its application to this case. Secondly, the taxation of the delegation of taxing powers, and thirdly, the delegation of plenary powers. My learned friend, Mr. Marcus, will address comparative law. He's told me he can do it in 7 minutes, so I'll take 23 and he'll do 7 with your leave. May I start with the New Africa cause of action? And my main focus is going to be to submit to you that this cause of action was not pleaded, and that to entertain it would be to be in breach of the respondents' right to a fair trial, because they haven't had an opportunity to present the evidence they would have done if the case had been properly pleaded. So I'm going to take you through the pleading of the grounds of review, just to demonstrate that New Africa was not pleaded. The original founding affidavit, Chief Justice, I'll give the case lines references. All of these papers are in the 011 folder. The first one is at 011-28. That is their grounds of review, and the founding affidavit, paragraph 18.9. They say section 7.4 is patently unconstitutional, and then they list the grounds upon which they contend that it is unconstitutional. The first is that the power to amend legislation is a plenary power that Parliament may not delegate. So it's an absolute bar on the delegation of plenary powers. Secondly, it affords the minister a power to impose an irreversible tax. So again, an absolute bar on the delegation of a taxing power. Those were the only two causes of action they raised. And it wasn't only in that paragraph of the founding affidavit. They returned to it at page 011-53 in paragraph 103 through to 105. They say again, section 7.4 is patently unconstitutional. First, can't delegate plenary powers. Second, you can't delegate a taxing power. Now, those were the only grounds of review raised in their founding papers. SARS answered, responded to those grounds of review in its answering affidavit at 011-700 in paragraph 16. And you'll see in paragraph 16, its various subparagraphs, it addressed only those two grounds of review which had been raised in the founding affidavit and nothing else. The minister dealt with it, with the grounds of review, in his answer at 011-301 from paragraph 52 through to paragraph 55. And again, the minister said there are these two causes of action, and he addressed those two causes of action. And then the minister said in paragraph 54, although the DA has not advanced this case, I nonetheless submit that even if section 7.4 were to be treated as conferring plenary legislative power, it would withstand constitutional scrutiny, and he referred to New Africa. The DA in reply came back to the issue at 011-434 under the heading Impermissible Delegation of the Taxing Power, paragraphs 74 through to 79. And what they said is the minister misunderstood our ground of review. The critical paragraph is 77. The minister mischaracterizes the DA's case. The DA's case is that unlike the power to amend the regulations to a statute, the plenary power to alter the provisions of the body of a statute itself, it has been held to be unconstitutional by the Constitutional Court. This will be addressed in a further legal argument. So, and then in the Part B reply, the DA returned to it again at 011-764 in paragraph 5. And they again reiterated that their causes of action, their grounds of review, were the two that I've mentioned. Nowhere in the papers did they raise the New Africa balancing test ground of review. And that, with respect, is fundamental because it means that my client and the minister have never had an opportunity to place before you the facts that would be relevant to the New Africa balancing test. There was lots of debate this morning about why not these provisions, why not those safeguards, why not these limitations, what are the processes and so on. You simply don't know because the parties before you have not been asked to address those issues at all. And it is obvious that you can't fail to raise the issue and then raise it after the papers have closed and contend, as the DA does, that I'm happy to argue this new point on the basis of the evidence already before the court, the uncontested evidence. That's not the point. The point is not that the evidence is contested or uncontested. The point is that the respondents have never had an opportunity to place all of that evidence before you to answer all of these important questions that you asked today. The High Court addressed the issue and held that the New Africa cause of action hadn't been pleaded, but then said the following. At paragraph 33, the DA's reliance on section 77 and the contextual approach, that's the New Africa approach, does not introduce a new factual case. It advances legal argument based on the facts already pleaded. And that is so, but that is with the greatest of respect to the court, not the point. The point is that the respondents have never been called upon to address all of these issues relevant to the New Africa balancing test. So you can't then apply the New Africa balancing test when the respondents have never been afforded an opportunity and called upon to address it. In the High Court, the ultimate ratio of the High Court was in paragraph 86 and 88 of its judgment. That is at 011-811. It said the cumulative effect of these features is that Parliament's control over the imposition of the altered rate operates only retrospectively and prospectively, that is by either confirming the measure or permitting it to lapse, but not contemporaneously at the point of imposition. In the specific context of VAT, whose operation is sanctions-based and practically irreversible, this structure assumes particular significance. And then in 88, they articulate the founding reason for their conclusion that says it rests in the absence of the present design of Section 7.4 of sufficiently defined statutory limits or mechanisms of prompt legislative control to ensure that the balance between the executive agility and parliamentary supremacy is maintained. That is exactly the point. That is the issue that a number of members of the court this morning raised with my learned friend. Those are issues are cardinal to the New Africa ground of review. But they were not raised, and you weren't to have the answers to those questions on the papers precisely because they were not raised. So we submit with respect that the New Africa ground of review has not been pleaded. You don't know, have not been given the information to which you would otherwise be entitled had it been properly raised. And to make do as the High Court did on the facts placed before the court for other purposes is with respect not to observe the requirement of audi alteram partem. The respondents have not been heard on this issue. So we submit with respect, and let me add this. You have seen from our heads of argument, Annexure A to our heads of argument, we've raised a very long list of comparable provisions. So, and we did that, that's the best we can do because at least that's law, not fact. But what it does is to show that this type of provision, which delegates the power to adjust rates and taxes, is a very commonly used, very long used, very frequently used mechanism. You deserve an explanation from the people in the know why that mechanism has been so important, has been so frequent, has been so pervasive all the time. If the question is what are the safeguards built into the system, you're entitled to those answers. If the question is why don't you have better safeguards, that is the question they need to address. If the question is, well, shouldn't there be a further limitation, those issues are important. They are not addressed because this ground of review was never pleaded. So we submit with the greatest of respect that the case cannot be decided on a ground of review that was never pleaded. Can I turn to the second ground of review, the delegation of a taxing power? Now remember, our learned friends, the DA's cause of action is that twofold. They say a taxing power cannot be delegated. And it's common cause. There's no debate. This court has often held that the power to impose a tax cannot be delegated. But it's a completely different question when you ask whether a component of a very large structure created by an act of parliament, whether the power to make adjustments to that component can be delegated or not. Now, again, we submit with respect that there is no absolute rule against the delegation of any component of an act by which revenue is raised. There is no suggestion that there is anywhere in the Constitution a bar of delegation in a revenue-raising act of parliament. The question whether such a delegation is permissible or not would be subject to the New Africa balancing test. In that test, one would ask yourself, does it satisfy the New Africa standard that this element of the VAT Act has been delegated to the minister? And then you apply the various criteria. The fact that it might be an amendment to a tax act may be an important fact. The fact that it may be a power to amend the tax rate may be an important fact, but there is no basis for the DA case which says that there is an absolute bar on the delegation of a power to set the tax rate. There is no reason why that, the legitimacy of that delegation shouldn't also be judged by the New Africa test. There's nothing in the Constitution to suggest that there is, in this case, whereas delegation is otherwise permissible, subject to New Africa. In this case, there is a specific bar on the delegation of a taxing power. The DA's case is, and has to be, as they say in paragraph 56 of their heads, that adjusting the rate of a tax is functionally the same power as imposing or abolishing the tax. But with the greatest of respect, it is not the same function. Look at the Tax Act. Look at the big structure of all of the rules Parliament has put in place in order to levy tax. I'm not suggesting that the tax rate isn't important. It is important. But it is Parliament that created the structure, who is taxed, how are they taxed, at what level are they taxed, and so on. And what it is delegated is this one component of theirs, and that is to change the tax rate. Again, I'm not underplaying the significance of that power, but the test is the New Africa test, that there is no absolute bar on the delegation of the subsidiary power to adjust the tax rate. May I deal briefly with the question of the effect of Section 77 of the Constitution on this question? With the greatest of respect, the structure of the Constitution is that it classifies bills before Parliament in 4 different categories. Section 73 applies to all bills. 74, bills amending the Constitution. 75, ordinary bills not affecting the provinces. 76, ordinary bills affecting the provinces. And then 77, money bills. So it is a broader structure in which the procedure, there are different procedures prescribed for different kinds of bills. And 77 is no different from the other categories. What it does in its 2 sections, by the way, it has no special procedures prescribed. What it does in subsection 7.1, it says a bill is a money bill if it does various things, if it raises taxes. But it starts off by saying a bill is a money bill. So it can't be a money bill if it's not a bill. It's a category of bill. It's a money bill if it does certain things. Subsection 2 tweaks that definition, which says a money bill may not deal with any other matter except. So it sets rules as to what may go into and what may not go into a money bill. But then subsection 3 says a money bill must be considered in accordance with the procedure established by section 75. That's the procedure for ordinary bills not affecting the provinces. So section 77 is not peculiar. It is a different category of procedure prescribed for Parliament. And there is nothing in the Constitution to suggest that when delegations are made in any of these pieces of legislation, that the procedure by which it is enacted in Parliament in any way affects the permissibility or the validity of the delegation. New Africa will determine whether it is a permissible delegation or not. But there is nothing in the Constitution to suggest that this one kind of bill may never delegate a significant power. The general rule applies, and that is New Africa. And again, he refers to we refer to our Annexure A. See how common a feature it is, and has always been, that Parliament delegates those powers to the Minister. May I turn lastly to the delegation of plenary powers. Our learned friends suggest that the foundation of their argument on this score is that the delegation of plenary powers is not permissible. They say that principle was established in Executive Council. But with the greatest of respect, firstly, Executive Council didn't establish such a principle, and if it did, the jurisprudence of this court has moved on since then. But if I may refer to Executive Council, in paragraph 62, the majority judgment of Judge President Shaskelson, where he firstly expresses himself against the proposition of the delegation of plenary powers, but then he says the following: it is possible that circumstances short of war or states of emergency will exist from which a necessary implication can arise that Parliament may authorize urgent action to be taken out of necessity. And then he mentions a national disaster and so on. So he didn't pronounce an absolute rule. He acknowledged that there may well be exceptions to the rule, and he didn't explore the boundary of those exceptions. So the Executive Council did not establish a general rule against delegation. And since then, there have been a number of other judgments, but it culminated in New Africa. We submit with respect that New Africa unambiguously held that there is no bar, no absolute bar, as the DA contends, on the delegation of plenary powers. They seek to make a distinction by drawing a line between plenary powers of taxation and plenary powers of delegation of other legislative powers. But with respect, the foundation on which they start, that Executive Council created an absolute rule, is a false foundation. And the law at the moment is the one announced in, or pronounced in New Africa, finally pronounced in New Africa. And that is that plenary powers may be delegated, there's no absolute bar against it, and it comes down to the application of the New Africa test. And that is the one thing they didn't plead. They didn't plead that if the New Africa test applies, that this legislation fails the test. Thank you, Chief Justice. I'll return for questions once my learned friend has addressed you on comparable law.
Chief Justice, members of the court, I will briefly address three topics on the comparative law. First, I will deal with the utility of comparative law in the present context. Second, I will make a brief submission on the no taxation without representation principle. And third, I will briefly address you on the case law with particular reference to the Colombian decision on which the DA relies. As to the utility of comparative law, what fetal assessment demands is a consideration of, and I quote, the reasoning used to justify the conclusions reached in each of the foreign jurisdictions considered, and whether such reasoning is possible in light of the Constitution's normative framework and our social context. Adopting that approach, the Canadian, English, and American cases to which we refer share a similar normative framework in three respects. First, all are premised on the separation of powers. Second, All recognize the centrality of the no taxation without representation principle. And third, all three jurisdictions require direct taxation to emanate from the legislature. Cognizant of those principles, the case law from Canada, England, and America have all recognized the permissibility of delegating taxing powers to the executive within certain limits, and we submit that there is no principled reason why the same approach should not apply here. As to no taxation without representation, the DA rightly places particular emphasis on this principle in the light of our own history. We unequivocally agree. The only point that we make is that the principle is of no less importance in England, Canada, and America. Indeed, in their heads, the DA make the point that in English law, its origins can be traced back to the Magna Carta of 1214. And the DA, like us, refer to Canadian Supreme Court authority as holding that the principle is regarded as a founding principle of parliamentary democracy. Again, we agree. Yet the DA seeks to persuade this court, in the words used in their heads of argument at paragraph 129, that, and I quote, "the reliance on comparative law goes nowhere." So let me turn then, lastly, to the case law. The DA does not take issue with our exposition of the English, Canadian, and American cases. It is not that they were unaware of them. They are the self-same cases we advanced in oral and written argument in the High Court, and they acknowledge as much in their heads of argument at paragraph 140. So the DA simply avoids these cases. Of course, they are not identical to the present case, which involves VAT, but that is a distinction without a difference. The DA's stance in this case is that it is never permissible to delegate a taxing power to the executive. The nature of the tax in question is irrelevant to that principle. But it is presumably for that reason that the DA places particular reliance on the Colombian case summarized and translated from a textbook. Bear in mind that the DA relies solely on an extract translated from a foreign language, emanating from a legal system which is unfamiliar, and certainly one that is not explained by the DA. But relying on the extract from the textbook, what emerges in the introduction is that there is a system of executive presidency in Colombia, which empowers Congress to delegate to the president powers to issue decrees which have the force of law when public necessity or advantage advises. And in terms of Article 150 of their constitution, these decrees can endure for up to 6 months. So at the outset, there's a radical difference from the position in South Africa. As to the actual decision, or more accurately, the extract from the decision, what emerges is this. The main challenge was that the goods and services to be taxed were indiscriminate and lacked specificity. From what can be gathered, the provision in question was not a presidential decree, but, and here's another crucial difference, taxing measures in Colombia are constrained by the Constitution, Article 363 of which provides the tax system is based on the principles of equity, efficiency, and progressivity. And the court stated that the provision under attack, which raised VAT by 2%, had been, and I quote, carried out in an indiscriminate way on very diverse goods and services. This had to be measured not only against the three requirements of the tax system, equity, efficiency, and progressivity, but also the principle of what is referred to as the social state. It seems that the court has interpreted the social state requirement in a way that resembles what we know as the minimum core in socio-economic rights, which this court has repeatedly rejected. The court stated, the fundamental right to a vital minimum is constituted as a limit or a minimum level that cannot be breached by the state in terms of the availability of the material resources that the person requires. and the court ultimately held that the provision in question, and I quote, violates the limits derived from the protection of the right to a vital minimum in a social state of law. So it's another radical difference from the position in South Africa, and it is certainly not consistent with the normative framework of our constitution. By contrast, there is a significant correspondence of normative framework with the systems in Canada, England, and America. And simply by way of conclusion, is that reliance on the Colombian case would not even meet the standard of admissibility under Section 1 of the Law of Evidence Amendment Act, which permits judicial notice to be taken of foreign law, but only insofar as such law can be ascertained readily and with sufficient certainty. Chief Justice, I don't know whether you want to get rid of me first or whether you want my learned friend back.
Your time is up.
Yes, I'm done.
Your learned friend can resume the podium.
If there are questions on foreign law, I will come back.
I'll do them.
Unfortunately, Mr. Trengrove, mine is on foreign law.
No, shall I pass
Yes,
the baton
thank
to my
you.
learned friend?
Thank you, Mr. Marcus. I just want to understand your argument. Mr. Manager said that the comparative, the foreign law that they rely on, in those instances, the approval is sought from Parliament before the increase comes into effect.
Yes.
What is the position? And he said that that is not the case in respect of the ones that you have presented before us. Is that the case?
Justice Mhlantla, the foreign law upon which we rely is in two categories. There is in the papers, and I'll give you the references now, a setting out of the position in a number of countries which permit the executive to alter rates of taxation. Those countries are Botswana, Kenya, Uganda, Zimbabwe, Nigeria, Lesotho, Ireland, England, and Canada. You will find that in SARS's answering affidavit at paragraphs 69 to 95 at 011-720 to 734. And on the papers, the DA makes a very important concession. They say in their replying affidavit at paragraph 72, that's at 011-783, and I quote, the bottom line is that there are some countries that permit executive alterations of VAT rates with varying degree of limitations and some that are not. So there is a concession at the level of legislative practice that there are those countries which do permit the alteration of taxation rates. And then there is the second category, which is really the one which respectfully this court will find possibly more helpful, and that is the attitude, the jurisprudence of the courts. And that is why we have placed before you the decisions in Canada, England, and America, all of which recognize the permissibility of delegation to the executive of a taxing power.
Thanks. Then the next one really relates to the issue of with no taxation without representation.
Yes.
The concern being that the announcement is of this alteration upwards, like in this particular case, is done without any public participation having taken place, and anything that has to take place will occur shortly thereafter in committees. Would that be sufficient when you have regard to, we know that a lot of people cannot afford to pay these taxes.
Yes.
With the income tax, it's a different case because there's assessment, but once it's announced, one has to pay, even the GOGOs, they will have to pay unless it's a zero-rated tax. Why should we accept that kind of an arrangement?
Well, it goes back to the framing of the case, and I don't want to intrude upon my learned friend's argument. Bear in mind that their case is an absolute one. It is never permissible for a taxing power to be delegated to a member of the executive. And the underlying principle upon which they rely is the principle of no taxation without representation. That is exactly the principle relied upon by both the Canadian Supreme Court and the American Supreme Court, and indeed the English courts. We have placed before you the Canadian Supreme Court of the Ontario English Catholic Teachers Association versus Ontario. In paragraph 69 of that judgment, the point is made, they first of all quote the English Bill of Rights of 1688, which established in England the principle of no taxation without representation, and then goes on to say, I accept that there is a constitutional guarantee of no taxation without representation in Canada. However, I conclude that the requirements of this guarantee have been met by the EQIA, that was the statute there under consideration. So what we are saying purely by way of the comparative jurisprudence is that the case that you have before you today is certainly by the standards of England, Canada, and America not an unusual or an outlying case. They recognize the permissibility of doing precisely what Section 7.4 permits in this case.
If we are against the minister and SARS, is government left without any remedy? Would government be left without any remedy to amend the VAT rate, whether it's upwards or downwards?
Well, Justice Mhlantla, when you say without remedy, one of the justifications which is advanced and which you will know from the papers is the need to act with flexibility and expedition. If you're asking me, could the government do that job expeditiously and efficiently, the evidence on the papers suggests that it does not have, that in the ordinary course, let me put it that way, the legislative program for the passing of a money bill, which is precisely what the DA insists upon, can be anything up to a year. I think that the quickest it's ever been done, but I stand open to correction in that regard, is something like 9 or 10 months. So the mechanisms exist, but the capacity to act quickly and efficiently, respectfully, are not there, and that is why a measure like 7.4 is so important. But if I could just add this point, since I'm doing the comparative law, in the American case to which we refer, which is Skinner, and this is in our heads of argument, there is an internal reference to a case called Bob Jones University versus the United States, in which the Supreme Court there said, in an area as complex as the tax system, the agency Congress vests with administrative responsibility must be able to exercise authority to meet changing conditions and new problems. Now that is again precisely why, or one of the justifications of why there is a need to be able to be nimble, the need to be able to react to changing and unpredictable circumstances, which is an important factor in the power conferred by Section 7.4.
One last question. What is the role of the Money Bill Amendment Act when it comes to this alteration or adjustment? Can one act within that act?
Well, that act, as I understand it, and my learned friend for the minister addressed the court at length on that, is that it prescribes a whole range of requirements over and above, or in addition to those which are prescribed by Section 27 of the Public Finance Management Act, which sets out the framework within which the budget has to be presented. And that framework requires exactly the kinds of uncertain projections and predictions about future spending, future debt and the like, which are time-consuming and cumbersome if they always have to go through the Section 77 process and simply do not afford government with the kind of nimbleness which is sometimes required.
Thank you. Thank you. Thanks, Chair.
And Jody.
My question is for Mr. Trent Grove. Isn't there a bit of a tension in the two arguments? The first one that highlights the pleadings, and secondly, your submission that there has never been really an absolute prohibition. And if I understand that well, it then means the law has never been as rigid as the DA makes it out to be. And if that is the case, then was it not the SARS's responsibility in explaining its own position to say, actually, my conduct still remains within the law, which includes the New Africa law? In other words, do you just stop at saying this is what you pleaded and that's it? Whereas your next argument will say, what you've pleaded is actually not even the correct law.
Yeah.
Do you understand what I'm trying to?
No, I understand that, but I do submit that one needs to understand that the case they pleaded was a case of two absolute rules. One is you can't delegate plenary powers, and you can't delegate taxing power, and this is a taxing power. Those were two absolute rules. Now, we submit that both those contentions are wrong, because there are no such two absolute rules, and that is what New Africa told us. But if they contend that this particular provision also violates the New Africa test or fails the New Africa test, that's an entirely different case and not one that they raised at all. Frankly, one gets the impression from the founding affidavit that the author had never read New Africa. So it is not incumbent on SARS or the minister, where the attack is very specific, two absolute bans, a ban on delegating plenary powers and a ban on delegating taxation powers. If your case is, well, you're simply wrong, there aren't two absolute bans. And the minister even raised New Africa, he referred to New Africa. But the DA didn't come back and say, sorry, I want to broaden my case. You also failed New Africa. They didn't do that. So that you can't then judge the case on the New Africa, under the New Africa rules, when the applicant who defined their case never invoked them.
But can we then criticize the High Court to that extent?
Yes.
In the sense that what the High Court essentially says is the same thing to a certain extent as the respondents say, that New Africa applies. This is the law. Yeah. And insofar as I can, with what I have been provided with, I then will determine
Indeed,
that issue as well.
Indeed, Justice Tambuza, that's exactly what it did, and one can see that it was well meant. But it was misguided, because you can't then acknowledge that the test is the New Africa test, and then apply the test on the evidence placed before you for other purposes. You can't say, well, that evidence is undisputed, and therefore I will apply New Africa on the evidence that happens to be before me. Where the respondents haven't been called upon to address the New Africa factors, it is fundamentally unfair to decide the case against them on a New Africa balancing test. It's an issue which they've never been called upon to address. And you'll see that's why I read to you the final paragraphs of the High Court's ratio. They say what they found fault with this provision is the lack of limitation. Well, the court simply doesn't know why there isn't greater provision for limitation, what the practicalities are, and why it isn't done otherwise, and what are the circumstances. Why is the same pattern followed through, I haven't counted them, but 20 or 30 or 40 other similar provisions? The court simply doesn't know because the issue was never raised.
Okay, thank you, Chief Justice.
Mr. Trangov, let's go back to the question that my sister Dambuza had conversed with you on a different basis, perhaps. The DA, in its papers, identified two bases for its attack. The New Africa multi-factor test was not canvassed. The minister, in the answering affidavit, sort of gave it a warning to say, you have not relied on this. And I seem to recall, correct me if I'm right, that in the replying affidavit, there was a superficial reference to it, or there wasn't any reference to it. And if there was some superficial reference to it, we know that a party must make his or her case in the founding affidavit. So the case that you had to come and meet was the case based on the two bases, that is the absolutist approach. Now, if you are correct on the pleadings position, that would mean that that would not be the end of the matter. Am I correct?
Yeah.
We would have to look at the basis upon which they have relied for the purpose of declaring this unconstitutional.
Indeed.
And the basis would be that the section, or would be the absolutist approach. Indeed. And if the absolutist approach upon which reliance is placed, like in Executive Council, the judgment by Justice Carlson P, Mohammed DP then, and Sachs, and New Africa. And then what would one do if they seem to have cut across a line in those decisions or judgments?
Well,
did I capture your argument correctly?
Absolutely. And let me just emphasize, those two grounds which they raised against us were two absolute rules. There's no debating or weighing. There are two absolute rules for which they contended. And they are still before you, and the High Court addressed them and dismissed them, we submit, correctly so. But if one is then talking about the finding the law, then we submit with respect that the law, finding the law on this issue is relatively simple since New Africa, because you have Executive Council. We submit that properly read, Executive Council, the majority judgment, didn't pronounce an absolute rule. It pronounced a general rule but acknowledged that it might be subject to exceptions. That was Executive Council. Come New Africa accepts that the delegation of plenary powers is permissible, but is subject to a multi-factor balancing. So there is no, in the first place, no conflict between the two. But in the second place, even if there is, then New Africa prevails for obvious reasons rather than the earlier judgment.
If this allegation had been pleaded, you would have met it with some form of evidence if the New Africa point had been pleaded.
Obviously. You just need to listen to the debate here today. Why wasn't there provision for greater public participation? Why is there not this limitation? Why is there not that limitation? All of those questions are legitimate questions if one is into the balancing exercise. But it's only the balancing exercise that brings up those questions. So that if the New Africa ground of review was never pleaded, then it is not permissible for this court or the High Court to determine the case on a ground of review that was never pleaded on the basis of evidence placed before it for other reasons. That is a fundamental breach of the requirement of audi alteram partem.
But is it possible or legally permissible to find that the DA's reliance on an absolutist rule, it's incorrect, but it's remove that averment or that submission. But when you consider its argument to say, even if it misconceived its position by stating that the absolutist rule applies, when you look at its argument, what the minister was purporting to do, it's not legally permissible. Can one come to that finding?
No, with respect, because what you articulate is opting for a third cause of action. That's not the cause of action pleaded. That is opting for a third cause of action, which you then justify or seek to justify on the basis of evidence led in support of two other causes of action.
But wouldn't that be a legal argument for a party to advance to say, we may be wrong on our submission that this was an absolute rule, but we do not fall foul of the fact that Section 7.4 and 7.1 do not permit the minister to impose tax. The alteration constitutes imposition of tax.
I'm not sure that I understand.
I'm done.
They did raise two absolute rules. They contended for two absolute rules. That is what they did. And what you're asking me is, as I understand it, can they not now argue for on a third ground of attack on the section, as long as it's based on the same facts? The answer is no. You can't switch cause of action just because you might be happy with the evidence that is before the court, when your opponents have not been called upon to produce evidence in support of the legislation. The only time when a court will allow a litigant to switch cause of action is when it can say, as a matter of certainty, that no other evidence could make any difference to the question. But for as long as the respondents haven't been given an opportunity to address the issue, you can't just say, well, I'll make do with what is there. The point is, you don't know what the answers are to all of these questions because the respondent was never given an opportunity to address these questions.
Okay, finally, so if we are to be with you, we would have to find one, that the High Court was incorrect in relying on an unpleaded case on New Africa, and that would have caused you substantial prejudice and violated your right of Audi. One. Two, relying on the absolute rule by the DA would be misplaced because of the pronouncements made in Executive Council and finally in New Africa. So the law is as it was stated in New Africa.
Yeah.
Then if you don't come within those four corners, one, you cannot piggyback on the High Court's judgment.
No, absolutely. Well, let me say this. The two causes of action which they did plead, the absolute rules, they were legitimately before the High Court. The High Court dismissed those grounds of review, but the same grounds come up on appeal before this court. So they are legitimately before the court, and it would be appropriate for the court to decide them. We submit that the correct decision would be to follow the High Court's example on those two issues. But when it comes to the third ground of review, the New Africa ground of review, the appropriate response would be to say that the High Court erred in entertaining that ground of review. This court cannot and will not entertain it, so that you can acknowledge that this is not a final pronouncement on the constitutional validity of the section, but it's a final pronouncement on the case, because the case was limited to two grounds of attack, and they are dismissed.
I'm not sure if the New Africa ground is a good ground. I'm just thinking about it. Insofar as the pleadings are concerned, if it emerged in the replying affidavit, it will cause the minister and the commissioner some prejudice if reliance was placed on what was stated in the replying affidavit. Let me leave it at that. I'll hear Mr. Mainecha.
Can I just make this point too, that SARS is also entitled to a fair hearing, and the issue never came up in its papers at all. So the fact that there was a little to and fro between the DA and the minister in reply doesn't affect SARS at all.
Thank you.
One or two questions from my side. On this debate that you're having with Justice Matopo, I suppose your position is that procedural fairness doesn't require you to respond to an argument that perhaps you should have anticipated but was never made. Yeah. And that's the bottom line.
That's the rule of pleading, is you plead your cause of action. You don't, if you're a defendant, you're entitled to say your cause of action is bad. You're not required to say, but you might have another cause of action, and I'll address it.
So on that score, it would seem that the High Court may have been correct in concluding that its interpretation of New Africa was such that the rule against delegation was an absolute, but they should have stopped there.
Yeah.
So let me then ask you this, Mr. Tengrove. It seems that at one level we assume that the law is settled with regard to the nuanced approach. But yet we found, even in today's debate, that it may not be as settled as we think it is. And it may be necessary in this judgment for the court to provide clarity, even though it may think that it has done so previously, but to the extent that it hasn't been totally settled. And my difficulty is that, do you distinguish between an original taxing power, so the power to create a new tax, and a derivative power from there that delegates a taxing competence to the executive to increase or decrease that tax? Or
no, we accept that there's a constitutional rule that says that only the legislatures may impose tax. So we accept that there is a rule that says that the VAT Act can't be enacted by subordinate legislation. It has to be Parliament that does it. But that is where that rule ends. We're debating a different question, and that is whether under such an act, a limited delegation to the executive is permissible. And the moment that is the question, there is no absolute answer to it. The answer to it is New Africa. And that is that...
Okay. So to that extent, Moshlaba, which says that a taxing power may not be delegated, would refer to the former instance that you give.
Yeah,
and that then can be read in harmony with New Africa.
Yeah, and we accept that unquestioningly.
Okay, thank you.
Let me also say, if you say the law isn't settled, it might depend on whether you see the law from up where you are or from down here where I am. But
there is a definite advantage from this vantage point.
What New Africa settled is that there is no absolute rule against the delegation of plenary powers. That's unequivocal. And that was the one ground of attack raised by...
Maybe clarity might be required on the distinction between these two types of powers that we've discussed now. Yeah. Thank you.
Mr. Trengov, you referred us to paragraph 77 of the DA's replying affidavit, in which the DA says, when the minister raised the issue of the New Africa test, the response by the DA was that the minister mischaracterizes the DA case, and they said that the DA's case is unlike the power to amend the regulations to a statute. The plenary power to alter the provisions of the body of the statute itself has been held unconstitutional by the Constitutional Court. That's when the minister was trying to say, well, this delegation could be permissible in terms of that test. On my reading of that paragraph, it suggests that the DA's understanding was that New Africa does not apply to the delegation of the taxing power or the plenary legislative making powers. In your submissions, you seem to be saying that New Africa has settled that point, that you have to meet the test as set out in New Africa so that that delegation may be permissible. Can you just clarify that for me? Because the two differences are these. I understand the DA to be saying it's a regulation, it's permissible. Let me just get to...
Let me say this. My submission is that New Africa settled the question whether plenary powers may be delegated. And
plenary legislative making powers, is that what you're saying or what?
Yeah. Not a taxing power, but a plenary power. In other words, whether the Parliament may delegate to the Minister the power to amend the Enabling Act. In other words, to amend Parliament's Enabling Act. That is how the concept was dealt with right from Executive Council through to New Africa. Now, New Africa finally settled that debate. Said there's no rule against the delegation of plenary powers. The validity of the delegation depends on this weighing exercise. What it didn't pronounce on is the other DA cause of action, and that is whether it is permissible to delegate a taxing power. New Africa steered clear of it by finding that the legislation before it was regulatory and not taxing. Justice Matopo, there was a bit of VAT in there as well, if you look at the order. But the ratio was confined to what the court held were regulatory powers and not taxing, regulatory provisions and not taxing provisions. So New Africa didn't settle the question whether it is permissible to delegate taxing powers.
Thank you, Mr. Trango. Thank you, Mr. Chair.
Thank you, Chief Justice.
Mr. Manager?
Before I was just asking for the grace to walk here, to walk up to here, and then say that, and then say that my learned friend, Mr. Bishop, is going to take the reply.
Oh, all right.
May it please the court. The first issue I want to address is one that really is fundamental to this case, which is what is the nature of the budgeting process and what roles do the different parts of the government play in that process. Because when one reads the affidavits of SARS and the minister, and when one listens to my learned friends, the impression one gets is that budgeting happens in Treasury and Parliament is an afterthought. But that has been the case in practice in South Africa because we've had a Parliament that's been dominated by single party, budgets have flown through. But that's not the constitutional design. The constitutional design is that the fundamental questions about how much money we raise, how much money we spend, how we raise it, how we spend it, are decided by democratically elected representatives. And it is a political process. It's not just what was referred to as a difficult and technical process. These are political decisions to be made, where difficult weighing decisions have to be made. Do we leave more money in people's pockets, or do we raise more money to spend on social services? And I want to refer to a quote, it's at paragraph 110 of our heads of argument, from the Supreme Court of the United States, when they recently considered the exercise of widespread executive powers to impose taxes, President Trump's tariff powers. And what the Gorsuch J said there is that, yes, legislating can be hard and take time. And yes, it can be tempting to bypass Congress when some pressing problem arises. But the deliberative nature of the process was the whole point of its design. The reason the Constitution requires these powers to be done by Parliament is because after deliberation, the decisions are likely to be better decisions and they're likely to be legitimate decisions. And when they're imposed by the minister without any consultation, without any notice, my client was a member of the GNU and found out about it on the morning of the budget speech. That does not achieve the purpose. The next point is about the process of budgeting and the fiscal framework. And effectively, the point is this: the announcement in Section 7.4 is insulated from parliamentary alteration. So yes, it will form part of the fiscal framework. The fiscal framework must be adopted by Parliament, and it can be amended to undo the VAT rate, to say we disagree, we don't want the VAT change in the fiscal framework. But then that doesn't undo the announcement. The announcement could already have come into effect before Parliament considers the fiscal framework. And the fact that they then amend the fiscal framework will have no impact whatsoever. There is also no provision in the Money Bills Act, in the PFMA, for withdrawing a budget. Once the minister places his budget before Parliament, Parliament then amends the fiscal framework, amends the various acts to bring it in line with their budget. Because ultimately it's Parliament that decides what the budget is. Next, I need to address the pleading point, which Mr. Trengo has spent a lot of his address on. So I'd like to go to where Justice Nuku ended off. It's page 011-435. And this is paragraph 79 of the DA's replying affidavit, importantly, Justice Matopo, in Part A. So this is in Part A, before the answering affidavits are filed in Part B. And so we say, yes, we have an absolutist case, but then we say, the factors relied on by the minister from New Africa in any event support the DA's case. And we list the factors, 1, 2, 3, 4. And all those factors, what you will see there, the actual arguments, are in the DA's founding affidavit. You will find the references in footnote 57 of the head, 57 of the heads. And then if I can take you to SARS's answering affidavit at 011-701 at paragraph 15.8. What SARS says there is, however, once it is accepted that the temporary alteration of an existing rate of tax is not per se prohibited, then the multifaceted factual inquiry set out in New Africa must be applied. The DA's affidavits do not address this inquiry in any detail. All the arguments advanced by the Minister in the answering affidavits to Part A and B are highly relevant, and I respectfully submit decisive in this regard. Decisive on the New Africa factors. He doesn't say, well, I'm not sure whether that's part of their case, and so I'm not going to say anything about it. He says the Minister's answered the case already. And then if you go on a few pages lower to paragraph 20, it's just the outline of what's addressed in SARS's affidavit. He says, I will now address the following issue: the legislative process from budget announcement, the many other examples where similar powers are confirmed, a comparative analysis of legislation and practice in foreign jurisdictions. All the arguments that go to the New Africa factors. And that's what the Minister did as well, in both the affidavits. So this argument that they didn't know what the case was and they would have put up other evidence is belied by their own answering affidavits. Their defense to the absolute case was New Africa, and here's why we win on New Africa. And they put up everything they could have wanted to put up on that argument. And now they say, you mustn't decide the point because we weren't called to address it. But they did address it. And they knew in Part A, before Part B, it was part of the case. The next argument I want to address is that none of the cases, Fedshaw through to Mhlaba, deal with this question of the alteration. Fedshaw is an alteration case. The power at issue there was setting the rate 6.45 cents on the rand. And that's what the court says is part of the taxing power. They don't say, oh, well, it's just the rate. They can do that. That's administrative. They say, no, that's legislative. But the question really is, I accept that none of those cases have specifically decided this issue, which components of a tax are part of the taxing power and which are not. It has not been specifically decided. But you have to look at the language used in the cases and the underlying principle and purpose of those cases. The language used throughout is the taxing power, the power to tax, the manner and the extent to which national taxes are raised and appropriated. That's from Shuttleworth. The manner and the extent, and the tax burden. And then you look at section 77 of the Constitution. And what does 77 say? Impose, abolish, reduce, exempt. That is the taxing power. That's what the court is referring to in Fedshaw, Mhlaba, Casino Association, Shuttleworth, New Africa. And you've got to argue, is there a reason in constitutional principle to draw the line that Mr. Trengove wishes to draw? To say, well, if it's a brand new tax, that can only be done by the legislature. But if you're increasing the income tax rate, increasing the VAT rate, increasing capital gains by huge amounts, just let the executive do it. We don't need any democratic deliberation about that. That's not an important political issue on which there should be public debate. That's just detail, because that's the argument. But the truth is that those questions about how much tax should be paid are the real questions that matter in everyday life. When we're talking about tax burden, when the Gogo in the village is talking about how much tax I'm going to pay, she's not worried about some new tax that might be imagined up. The taxes, the kinds of taxes are all there. We know what the types of taxes are. What matters is how much of those types of taxes are paid. And so to say that question, that fundamental question, can be simply kicked by the legislature to the executive, is to undermine the principle of taxation without representation. We are criticized for adopting an absolute rule. But all the parties here agree that there is an absolute rule. We just disagree what it is. Mr. Trengove fairly said, we accept there is a constitutional rule that you may not delegate the power to tax. All we disagree about is what is the content of that rule. So it is not the case, and Mr. Trengove again correctly made the submission, that New Africa said in the taxing context that everything is a multi-factor balancing test. New Africa applies Shuttleworth, and it says if it's a taxing power, it may not be delegated, full stop. The debate we're having is not about whether there is an absolute rule or not. There is an absolute rule. The question is, where is the line? Is the line at when you're changing the rate, making people pay more tax that they can never get back, that they will never see that money again? Is that part of the taxing power, yes or no? That's the question for this court. And we submit the answer is obviously yes. Because if that's not part of the taxing power, then the prohibition on the delegation of the taxing power is hollow. Because the core thing, the thing that really matters, has been taken out of it. Finally, on the comparative law, I'd just like quickly put out in our defense. Firstly, to say that the US, the Canada, and the UK, their position is inconsistent with our law because they say anything can be delegated, even the power to impose new taxes that everybody says here we cannot delegate. So it doesn't help to look at those countries because they have a fundamentally different starting point. And finally, on the Colombian decisions, the author of the book was the president of the Colombian Constitutional Court. So I think we can rely on what he said.
Sorry, Mr. Bishop, if I misunderstood you, my apologies, but you said there's no debate that a component of the rule may well constitute an absolute rule. So there is an absolute rule, that's what you said. But
yes, there's no debate that the taxing power may not be delegated.
But you're saying that the debate, the dispute is that what would constitute
The
taxing power.
Exactly.
But in your argument, the original power, as well as the power to adjust upward, downward, would constitute the taxing power, not so?
Yes.
In your,
Yes.
So what would be left to delegate if delegation was permissible?
So what's in Section 77 could not be delegated. So the imposition, the abolition, the reduction, or the exemptions from taxation. But how this actually operates in practice, Justice Colopin, will depend on the particular type of tax.
I'm just asking for an example that makes the distinction, because if we proceed on the basis that there's a core power that may not be delegated, but there's a peripheral power that can be delegated, and if this court is required to provide some clarity on that, then it's not clear to me where to draw the line, because on your argument, there's only one line to be drawn, and that's the line to be drawn right across it.
Well, Justice Colopin, we would say what you have to decide is this case. And so this case is one about a particular type of tax, which is irreversible, that cannot be repaid. So similarly, for example, setting the rate of income tax, it may be different because that's not actually a delegation, because the tax will never be finally collected without parliamentary approval. So that may be permissible because it's not a delegation, not because setting the rate is not part of the taxing power. There may be other examples where they're regulatory charges, not taxes. But if they're taxes, they may, I don't know, Justice Colopin, I don't want to say exactly.
I think the difficulty is that we haven't had argument on this issue then.
But I don't want to run away from the question because it's an important one. What we're saying is the line cannot be where SARS and the minister wants to draw it, because that would make the prohibition on the delegation truly hollow. The line is at least where we draw it, setting the rate of VAT. Where exactly the line is in other situations will have to be decided there. But I think the core question is this the type of issue that should be subject to democratic debate in Parliament? Because that's why we have the rule. And that's the purpose of way to answer the question.
Right, thank you, Mr. Bishop.
As the court pleases.
Thank you, everyone. Judgment is reserved. Court adjourns.
Thank you so much. Thank you very much. We'll see you again soon. Michael. That was great.